Lord.
Ms. Hamad?
Yes. The hearing is in the matter of case number CFI 98-2021 before His Excellency Deputy Chief Justice Ali Madhani. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the registrar's and on the judge's instructions. The claimant is represented by Clyde & Co. and the lead counsel is Mr. Nicholas Craig KC, and the defendant is represented by HFW and the lead counsel is Ms. Zoe O'Sullivan KC. Thank you very much.
Hello again.
Hello.
Yes. Hi. I would like to tell you I have read your submission. I've been through the skeleton argument twice. Yes, I believe we are dealing with the subject matter of the anti-suit injunction with a slight, little bit smaller application of the joinder of Buhaira International, what's called, is it maritime company? We had our first round. The interim we did, I think 2 weeks ago. He wasn't successful in that, Mr. Craig, and today maybe you would have it. You have to try it and battle it all long. Ms. Sullivan, you're with us too. I don't know to what extent. I think you are also representing the proposed new defendant. Is that right?
Yes, my lord.
So I think you would be said a little bit about that toward the end.
Yes.
Is there any before I give you the trial timing? Is there any housekeeping? There is any matters that we need to clarify? Is there anything, or we all set?
From our perspective, we're all set.
Ms. Sullivan?
The same here. Thank you, my lord.
Okay, appreciate it. Well, Mr. Craig and Ms. Sullivan, I think, giving the number of submission document and evidence in hand, I might think you might finish the first application yourself in 45 minutes, maybe, before the rebattling and before the joinder application. So do you think does that make sense?
From a personal perspective, I think it depends upon how quickly I get through the various things that I want to take you to.
What do you propose timing?
I have a feeling that I personally am likely to be speaking probably for 45 minutes to an hour.
Okay, Ms. Sullivan?
I think I can be quicker than that in response because Mr. Craig will have done a lot of the spade work. I think our time estimate will be more than sufficient, my lord.
Agree. In that case, Mr. Craig, the mic is yours.
Thank you, Your Honour. I intend to divide my submissions into 3 parts. I appreciate that you've read the skeleton arguments and are aware of the issues, but I do think it's very important, first of all, to deal with the background to the claim and this application, and that's what I intend to do in the first part. Secondly, I want to look at some of the relevant cases in order to look at the relevant legal principles. And then thirdly, the submissions as to why we say that the bringing of the proceedings in Sharjah is unconscionable, or to put it another way, vexatious and oppressive. The fourth part of my submissions is the joinder, and I'm not sure whether to deal with that. You'd prefer to deal with that after dealing or hearing submissions on the anti-suit, or in conjunction with my submissions on the anti-suit. At the moment, I was planning to do everything at once.
I'm at your hand, yeah, I'm okay.
Yeah. So in terms of the background to the claim, that part of my submissions, I'm going to divide into 3, if I may. First, to say what the claim in these proceedings is about. Secondly, to look at the conduct of these proceedings and the orders that have been made, and in particular, what has been determined by Justice Giles. And then thirdly, to look at the proceedings in Sharjah, and in particular, what is being advanced in those proceedings, because there is, we say, some misstatement as to precisely what is going on in those proceedings. Now, as you know, the underlying claim is an insurance claim in respect of, or potentially made under two policies. That those policies ran for the period between the 10th of June and 9th of June 2019. One of the vessels insured under the policies was a tanker said to be owned by the second respondent, Abus. In about 2019, December 2019, Horizon and Abus discovered that the vessel was missing. About a year later, Horizon notified the insurers that the vessel had disappeared. And then in about April 2021, it was discovered that the vessel was located in Iran and was now in the service of the Iranian Navy. It wasn't, though, until the 25th of October 2021 that Horizon purported to give a formal notice of a claim for the loss. Now, before receiving a response from ABNIC on that claim, on the 7th of November 2021, Horizon filed a complaint with the Insurance Authority. 4 days later, on the 11th of November, ABNIC issued the claim form in these proceedings.
So the Sharjah insurance claim started 4 days earlier to the DIFC.
Well,
oh no, sorry, the service.
Yeah, so the Sharjah complaint, the complaint to the Insurance Authority in Sharjah, yes, started 4 days earlier, but we'll come to is they are not proceedings, and I'll come to why we say that, because that was the decision of Justice Giles, and that's quite critical for the purposes of this application.
Yeah, my understanding as well, Mr. Sullivan is saying that's how the insurance proceedings starts in the UAE, according to the UAE civil procedure law. Is that right, Mr. Sullivan?
Yes, the point is, my lord, that this is mandatory. The only way an insurance can make a claim under UAE law is to start off by making a complaint to the insurance authority. Whether or not it is strictly speaking a court of law is not to the point. The point is it has no other route to make a claim.
Oh, I see. I just want to make sure that's your point. Yes. Yes, Mr. Craig.
So, yeah, I'm going to come to that because I'm going to make clear precisely what we say about it. Now, on the 27th of December 2021, Horizon issued an application for an order that this court does not have jurisdiction. And in the alternative to that application, it applied to strike out this claim on the grounds that it constituted an abusive process by reason of the prior existence of the complaint to the Insurance Authority. Now, if I could just ask you, please, to look at that application notice at J1.
Yeah, bear with me. Yes, I do have it before me, yes.
Fantastic. And you'll see that there are two parts of the application. The first is point 1, a declaration. You'll see at the bottom of J1, declaration the court does not have jurisdiction to hear the claim pursuant to Article 5A2. And then it says in the alternative, the claim is struck out as an abusive process of the court's process. And then if you could please look at the bottom of J2, you will see that it said that in respect of the order sought to strike out the claim, it refers to the fact that written notification of the claim was given, etc. And then 9, in light of ABNIC's failure to make any payment, Horizon filed a complaint against ABNIC before the Insurance Authority on the 7th of November 2021. And then it says, following ABNIC's failure to engage with the Insurance Authority proceedings, Horizon escalated its complaint to the IDRC, talks about Horizon becoming aware that ADNIC's lawyers had filed a comment rather, on the system. And then it says at 13, and this is the critical point, in the premises, Horizon had commenced and filed proceedings before the onshore insurance authority before ABNIC filed this claim on the 11th of November. Those proceedings, therefore, constitute lis alibi pendens, and C, ABNIC has filed this claim in order to frustrate the IA proceedings, as well as any steps taken by Horizon to enforce in the Sharjah courts any award made in the IDRC in its favour. Issuing the claim in such circumstances and with such a purpose constitutes an abuse of the court's process and ought to be struck out. Now, pausing there, the position of Horizon on that application, therefore, and that's a fundamental premise of that application, is that if proceedings are already pending before one court, you cannot commence parallel proceedings in another jurisdiction. And the second point it made, and it related to that, is it is abusive to commence proceedings in one jurisdiction where there are already pending in another jurisdiction proceedings concerned with the same dispute. Now, we say, having advanced that position, it is abusive for it to advance the contrary argument, which it is currently seeking to do on the application for an anti-suit injunction. And in any event, we say that entirely undermines their argument on this application that essentially two sets of proceedings should be permitted to proceed in parallel. Now, I want to look at the decision of Justice Giles of the 27th of April 2022, because in its skeleton argument, the respondents have misstated what was actually found by the judge. Now, the decision starts at its bundle reference I7.
If you just allow me, I'm making note of your final last remarks.
Of course.
Yes, please.
Apologies.
No.
Page I7, please, the decision of the order with the reasons of Justice Roger Giles.
You said I7, is it?
I7, yes.
Yes, the first bit, okay.
Fantastic. And then if I could ask you, please, to move to paragraph 12 of this decision, which is at page I11.
Yes, I'm there.
And this is all in the context of the discussion of the jurisdiction agreement in the contracts, and the judge concludes at paragraph 12, the agreements and the policies on the jurisdiction of the courts of the UAE in their ordinary meaning confer jurisdiction on the DIFC courts as courts of the UAE and are specific, clear, and express provisions in that respect, unless there is reason from their text or the surrounding circumstances to give them a different construction. And then he refers at paragraph 13 to the 2 points that were raised by Horizon as to why a different construction should be given. He says that they should be understood to be agreements to submit any disputes under the policies to the Sharjah courts, alternatively to the onshore courts of the UAE, meaning excluding both the DIFC courts and the courts of the ADGM. And the first point that was raised at paragraph 14 was that there had to be a material and sufficient link between the parties, facts of the case, and the DIFC. And at paragraph 16, you will see that the need for a link to the DIFC was rejected. And he says a link to the DIFC is not necessary for an agreement as referred to in Article 5A2. That is the point of an opt-in agreement. And it's common for parties to agree to submit, for example, their suits to, for example, the commercial court in England, even if there be no connection with the country. And then at paragraph 19, he says, given the width of the choice of the courts of the UAE, the connection with Sharjah is not a strong argument for confining the phrase to the Sharjah courts or the onshore courts of the UAE. It does not provide a sensible reason for limiting the agreement on jurisdiction to the Sharjah courts alone out of all the courts as of the UAE. And paragraph 20, he refers to the fact that the second limb of the submissions made in support of the point that DIFC courts were not included within the UAE. It was said that ABNIC's insurance activities in the Emirates were subject to the law on the regulation of insurance operations and the dispute resolution procedure in its Article 110. Argument that went on, the dispute resolution procedure involved the first decision by the insurance authority which could be challenged in a court, that the courts would receive a challenge with the onshore courts, and that against that background, the parties would have intended the onshore courts would deal with their disputes, and it was implausible that there should have been a choice in favour of the DIFC courts. And then he says at paragraph 21, refer in more detail to the insurance law in connection with abusive process. As there explained, the dispute resolution procedure deals only with an insured taking a complaint to the insurance authority, and even as to such a complaint, provides for a challenge to go to the competent court of first instance. This is not limited to the onshore courts. It is open to the parties to choose their court or courts of competent jurisdiction, and I see little weight in this in excluding the offshore courts from their choice. Now, we'll come to it in a moment, but what the learned judge was saying there was that after you have had a complaint to the insurance authority, you were not, as was submitted by Horizon, limited to bringing an appeal or a challenge to that decision in the onshore courts. So you're not limited to bringing it just in Sharjah. And it says here at paragraph 21, as you see, in that regard, the submission included the DIFC courts could not receive a challenge, as it was put, cannot have jurisdiction under the insurance law, because by force of Article 4.4, etc., a DFSA authorised company conducting insurance activities in or from the DIFC was restricted to reinsurance business. And it says, the best I understand the argument, it was said the exclusion of other insurance business from the DIFC evidenced the policy, the regulation and enforcement of that business and its disputes should also be excluded, with the results the DIFC courts could not hear a dispute arising under or in relation to insurance contracts. It says the submission became quite confused. Then at paragraph 21, he refers to the fact that he says, it's not enough, I'm unable to see, it is enough that I'm unable to see that the restriction on insurance business in or from the DIFC has any bearing on the ability of the DIFC courts to hear insurance disputes if the parties to the insurance contract agree that it can do so.
I see
And then,
this.
yes, and then at paragraph 26, he says, in my view, reasons not been shown to depart from the ordinary and natural meaning of the conferring of jurisdiction on the courts of the UAE as including the DIFC courts. So that was the position with respect to the choice of jurisdiction. The next point he turned to was the abusive process arguments, which were advanced, which was essentially to the effect that because the complaint had been issued 4 days before the proceedings in the DIFC had commenced, there was an abusive process by ABNIC of this court, and he roundly rejected that. But you'll see at paragraph 37 of the judgment, it says Horizon's assertion of abusive process was put with a degree of confusion between them in essentially 2 ways. One was that there was an abusive process for ABNIC to seek to sidestep and evade the application of the dispute resolution regime imposed by the insurance law. The other was that there was an abusive process because prior to the commencement of the proceedings, the dispute had been submitted to that dispute resolution regime. And as it was put in the skeleton argument, ABNIC brought the proceedings to frustrate a bona fide claim made by Horizon under that regime, etc. Now, at paragraph 41, the judge refers to the first point, first of all, and he says, for whatever reason, perhaps because declaratory relief and claims by insurers for negative declarations are not ordinarily available in the civil courts, the dispute resolution regime under Article 110 regulates only complaints by an insured against an insurer. Restriction in clause 3 of the article, if it precludes a court from accepting a claim, can only apply to claims against the insurer. It follows that ABNIC is not acting contrary to the dispute resolution procedure in Article 110 in bringing these proceedings against Horizon claiming declaratory relief. He then says, should still be asked, though, whether ABNIC is not acting contrary to the dispute resolution procedure in Article 110, it can be found the regime that is to cover the field so that the only way an insurance dispute can be settled is by a complaint by the insured. That is, it is not open to an insurer to initiate any form of resolution procedure, including bringing proceedings. Nothing in the article so provides, and it is evident the regime does not cover the field from the provision of Article 6 of the decision that the committee shall not be competent in relation to insurance disputes that are subject to an arbitration clause. That is, the parties to the insurance contract are left free to agree upon other means of resolving disputes between them. In the present case, they've done so by agreement upon a jurisdiction which permits claims by insurers to negative declarations.
Mr. Craig, if I may ask, was there any legal evidence put before Justice Roger? I mean, during that hearing, like whether there is a legal expert attended or a legal, let's say, UAE, I mean,
there was no
article or anything about Article 110 to 114 of the UAE law?
There was no expert, but but those materials were there before him, and he made a decision on it. And so whatever, I mean, so therefore it's not open, as it were, because the decision has been made between the parties. That is now binding as between them. So it's not open, as it were, to reopen that finding or to question its correctness.
Oh, no, I'm just curious how he landed into that conclusion. I mean,
well, it was based upon his reading of the relevant articles.
But I'm sure he did, yes.
Insurance law, yes. Then at paragraph 44, he turns to the fact, I turn to the second way in which Horizon contended for abuse at process. At least initially, the argument was a complaint that although ABNIC had not previously disputed the availability of the Article 110 dispute resolution procedure, having received notice of Horizon's complaint, it did not properly engage with that procedure, but brought these proceedings to frustrate, or as it also put, to stymie that procedure. It said ABNIC rushed to issue the proceedings first, etc. Then it said, at the hearing, the argument turned to the doctrine of lis alibi pendens, which had received but passing mention in the skeleton argument, not as an argument for a stay, but as a factor in finding abuse of process. So in other words, just to be clear what's meant there in relation to the argument on lis alibi pendens, Horizon was saying that the complaint to the insurance authority constituted proceedings, and therefore the proceedings commenced by ABNIC in this court were second in time, and therefore they were abusive. And you'll see at paragraph 47, there was reference by Horizon to a decision in the English court in Lehman Brothers, where they held that a mandatory conciliation process prior to litigation under the Swiss Civil Procedure Code amounted to court proceedings and came with a convention provision for a stay of proceedings involving the same cause of action, etc. And the reasoning was that the conciliation authority was an integral part of Swiss civil procedure as a mandatory first step in the resolution of civil and commercial disputes within the court system, and the trial process could not be commenced until it had taken place. And so with reference to other decisions to the same effect and decisions on tribunals whose decisions could give rise to res judicata estoppel, Horizon submitted the authority by its committees was to be regarded as a judicial body whose proceedings were a lis pendens. That submission was rejected by the learned judge.
Mr. Craig, you're not arguing now there is an estoppel that Ms. Sullivan cannot run this argument. Is that right? Like what happened before the insurance committee is starting a proper proceeding of the UAE law. You're not talking about estoppel at this stage, yeah?
Yes, I am saying she's not able.
Are you saying that?
Argue. I am
Yeah.
saying that. Not able to argue now that the proceedings before the insurance authority constitute proceedings.
Before
She's
Sharjah court, before any of the UAE court as defined in the jurisdiction clause. Yeah, that's
it is
what
not,
you're saying. Yeah.
So because we've already had this fight and
Yes,
Horizon has lost. We've had this fight because if it had been determined the other way, that there was already that effectively the proceedings had been commenced prior to the DIFC proceedings by virtue of the complaint being lodged, then we might be in a very different situation. But we're not, because it has, and this is fundamental because you'll note throughout the skeleton argument of the respondents, it's scattered with claims that proceedings were commenced before the DIFC proceedings were commenced. And that is incorrect. And it is contrary to the finding that was made by Justice Roger Giles to the effect that those are not proceedings. And that is critical. And it goes to the question of what is first in time, etc. So that is our position on that.
May I just say that's not a point I'm seeking to make, my lord. I'm not seeking to rerun the lis pendens argument.
Okay, that's good. Thank you. But I wanted to bring it to your attention, Emily. I had just made two notes, one in my laptop and another one in my paper notes as well. So I wanted, but since you raised it, it's yours. You will run through this later on, Ms. Sullivan. Yes, Mr. Craig, sorry for interruption.
No trouble. And then you'll just to finish off this bit, you'll see that he refers at paragraph 48. This is I-20 to the fact this is not a Lehman Brothers situation. Complaint to the authority and the decision of the committee may be a mandatory first step where an insured disputes the full or partial rejection of a claim, etc., but not where the insurer brings proceedings. The dispute resolution process is not an integral part of the judicial system. It is an administrative process of partial application with the committee's reporting to the authority, and by clause 4, its result may be challenged in a court. There is a clear distinction between the authority by its committees and the court, and the committee's decision is not in the workings of the judicial system, but something which may be challenged in that system. I do not think the doctrine is attached. And then he refers to the fact this is not the end of the matter. The considerations underlying the doctrine, avoidance of a party having to litigate in two places at once, and avoidance of possibly inconsistent decisions may be added to Horizon's complaint earlier described when asking whether in all the circumstances the bringing of these proceedings by ABNIC was an abusive process. However, when the parties have agreed to confer jurisdiction on the DIFC courts, as I have held, it should not readily be found that invoking that jurisdiction is an abusive process, etc. And it says at paragraph 50, there are difficulties with the complaint, no occasion for ABNIC to dispute, etc. And in particular, you will see that he refers to the fact that you can't say that we've deliberately stymied or a deliberate frustration or stymieing of Horizon's invocation of that process in response to the notice of the complaint cannot readily stand with the instructions of the 3rd of November before any such notice to decline cover and bring the proceedings. Those instructions may be seen as rushed in the light of the email, but equally it can be said that Horizon and ABIS were the ones who rushed, because under clause 1C of Article 110, the right to submit a complaint only arose when there was a dispute concerning the claim, and ABNIC had not rejected the claim, but had said it was considering it. Paragraph 51, it is a consideration Horizon will need to fight on two fronts: prosecuting its complaint before a committee and defending ABNIC's proceedings. Now, just pausing there, it's prosecuting its complaint before a committee, not prosecuting a complaint before the Sharjah court, which is now what they're seeking to do. It's evident ABNIC will not participate in the proceedings before the committee, and excessive burden on Horizon is not clear. It's likely that if there is a decision by the committee adverse to ABNIC, it will challenge the decision, and the challenge will end up in tandem with these proceedings, so that Horizon will have the double burden in any event and will be where we are now. Even
well,
if
Mr. Craig, I mean, to be fair to Ms. Sullivan, I mean, being with us here, you saying she's changing her position. What I thought she's maintaining that and that's as always the cases. What she said, we went to the Sharjah, this is what called the insurance committee, because we think there were insurance claims starting. We are in Sharjah now because we're appealing that decision of the insurance committee rejecting the jurisdiction of the committee itself for a reason that we're not happy with it. I don't think she's changing anything from that aspect. She said she might not run the abusive process argument or the other argument we're talking about, whether it's proceeding or not proceeding. But she's not. I'm starting fresh proceeding before Sharjah court nowadays. Yeah.
no, well, we'll come to that in a second. We consider they are starting entirely fresh.
You think there is change of circumstances?
Well, yes, we do, because not only they're not just appealing the decision of rejection of jurisdiction. And I said I'm going to take you to what's being pleaded.
Oh, we'll go on 10. We will go on 10. I just want to, I wanted to follow up with you on it.
Yeah. And so but the point is that challenge to the insurance committee decision can obviously be brought in the DIFC as well. It doesn't have to be brought in Sharjah. And that is effectively
that's what Justice Roger has said as well. Yeah.
Exactly. Yes.
I see.
Yes.
Go on.
But just to be clear, what the judge was considering for the purposes of his determination as to whether or not there was an abuse of process was the status and effect of the complaint to the insurance authority. He was not considering, not and it wasn't at the time, there was no such thing. He was not considering proceedings in Sharjah and whether or not there was any abusive process in connection with them. And he determined at paragraph 52, finally, that there was no abusive process by my clients in bringing the claim in these proceedings. Now, after that decision, Horizon made an application for permission to appeal in May 2022 without any supporting grounds of appeal or skeleton argument. And those grounds of appeal and skeleton argument were not submitted until later, after the deadline, and that was found of itself by the Chief Justice, by his order of the 5th of August, to have been an abusive process, meaning that that application failed without needing to consider the merits. Now, nonetheless, Horizon has renewed its application for permission to appeal to the Court of Appeal, and the obvious consequence of that is to stop the progress of the claim brought by Abnick in this court.
Well, Mr. Sullivan, was you, instructed then by the first appeal notice?
No, my lord, I was instructed just the day before last week's hearing.
Oh, I see.
But I'm aware of, I've seen the skeleton arguments.
Now, going back to the chronology, we have the decision of Justice Giles on the 27th of April. We have the application for permission to appeal that decision at the end of May 2022. And then on the 13th of June 2022, the IDRC dismissed Horizon's complaint on the grounds that it had no jurisdiction. Now, despite the IDRC having found it had no jurisdiction, and also Horizon having filed an application for permission to appeal the order of Justice Giles, on the 7th of July 2022, Horizon and ABIS started proceedings before the Sharjah Court of First Instance. Now, in its skeleton argument, the issues which are put before the Sharjah Court, we say, have been misrepresented. The Horizon and ABIS are not just asking the court in Sharjah to find that the IDRC did have jurisdiction and the case should be reverted to it as is suggested. And if I could ask you please to look at the statement of claim in the Sharjah proceedings, it's at K227, and I apologize, I'll have to look at the English version because I don't speak.
No, we can see both. We can see both. Yeah.
Yeah.
K1, is that K1?
K227.
May I say, my lord, this is a dreadful copy, and I think there's a better version at K325.
K325.
I think it's, I'll be corrected if I'm wrong, I think it's the same document, it's just the first version is really difficult to read.
I'm sorry, I've based my submissions on this document, so if you can bear with me, I'm afraid
Right, that's trying to be helpful.
I'd rather stay on this document. If there's anything which is illegible or is difficult to read, then no doubt we can look at the other document. But I'm at
K325, and this is an English translation, I guess, of the.
Yes, I was going. If I could ask you, please, to go to K219.
For the previous document, yes.
Yeah.
Yes, here where it starts, introduction.
Yes, and so you should see the statement of claim which has been filed by Horizon and ABIS in the before the Sharjah courts. And you will see, if you turn to, it recites obviously the background, etc., and the finding of the IDRC. And then at page 227, you will see the what are described as the grounds of challenge.
You're confusing me now because I'm in the 319 and then you want me to ask a 200 something.
I said it was 219 was the start of the document.
That's it.
K219.
K219 is it's a bad image document, which is difficult to follow. And I think it's the same document that in 325, Mr. Sullivan had referred to.
It is, but I'm afraid I have made reference and my submissions, I've got the reference number. I can't give you the reference numbers to the other document. I've looked at this, and what I said was that to the extent there is something which is unclear in this document, we can undoubtedly refer to the other document, but I'm afraid...
No problem. If you just follow the paragraph numbering, and because I'm reading from a better version, you just refer to the paragraphs, please.
So at paragraph...
Brief background of the dispute.
So we've got the, first of all, above the heading, paragraph 21 refers to the fact that the two plaintiffs maintain all previously submitted pleas and defence before the Insurance Authority and before the Insurance Dispute Settlement and Resolution Committee, and considers the same to be an integral part of the present challenge. That, of course, is their submissions were that under the policies, we were obliged to indemnify them.
This is the title reservations, no?
Yes. Now, the first point is that paragraph A, this is the first ground of challenge, is the misapplication and misinterpretation of the law and ignorance of a substantial defence submitted by the two plaintiffs regarding the absence of an arbitration clause in the insurance policy. And what you will see is that there is reference in the following paragraphs to argument as to why the Insurance Authority was wrong to find that there was no jurisdiction based on there being an arbitration agreement, and also on the basis that English law was the governing law. So that's their first section, and that's what effectively is said by the Horizon and ABIS on this application to be the essence of the Sharjah proceedings. That is not correct, because if you look at it is above paragraph 27,
yes.
K231, you see the heading, it says misapplication of the law and misunderstanding and misinterpretation of the express wording of the policy concerning the exclusive jurisdiction of the courts of United Arab Emirates. And at paragraph 39, there is reference to the very clause which Justice Roger Giles considered. The policy states that each party agrees to submit to the exclusive jurisdiction of the courts of the UAE. And then at paragraph 41, it is said, whereas the courts of the UAE means the federal and local courts in the UAE and does not include the free zone courts such as the courts of the DIFC. So you'll see there that that is precisely the argument that was put before Justice Roger Giles, precisely the argument which has already been determined as between these parties, namely that it does include the DIFC courts. So they are seeking, obviously, to have that question determined again. And not only that, but you'll see that they repeat the submission at paragraph 44, which they made before Justice Roger Giles.
But is it the insurance committee anyway? I mean, dealing with the issue of jurisdiction, first of all, and I mean, locating heavy weight in the matter of application of English law, maybe, or maybe something like party has signed, referred party have signed, maybe, what's it, arbitration agreement or something?
I'm sorry, I don't follow.
The reasoning of the insurance committee
yeah.
for rejecting that claim was mainly what called the signing of arbitration agreement, isn't it?
It was for two reasons. They said, yes, they considered there was an arbitration agreement. And secondly, they said that because English law governed, they didn't have jurisdiction.
And then with all argument we can see here is around that two limbs, isn't it?
No, it's not. That's the point I'm making to you. That they are saying that this is a different point. That point was point A.
Mm-hmm.
This is point B, where they are saying, they're asking that they're saying that basically that the DIFC court has no jurisdiction because in the insurance committee referred to the fact that the DIFC court had accepted jurisdiction. And so this is a challenge, that finding, and it's a challenge which is being made in the Sharjah court, and it's a challenge which is being made by ABIS and Horizon, despite the finding of Justice Roger Giles that the DIFC court does have jurisdiction. And it is an attempt to rerun entirely the arguments that were advanced before Justice Roger Giles as to the jurisdiction of this court.
But have this insurance committee have found that the DFC has found jurisdiction for its own? I don't know, I remember they were mixing up between the DFC, whether it's an arbitral committee or a court of state or something. But I do recall I've seen somewhere in that decision where they're referring to the DFC making a jurisdictional finding in their favor, and that is as a support for them to strike it out as a referral to arbitration or something like that.
Exactly, exactly. That is correct. That is correct.
I see. Okay, I see. So I see, but in your argument, I mean, what's said in 41, I mean, Horizon arguing that DFC is not a court that mentioned, or a court supposed to be a court referred to in the jurisdictional clause that include United Arab Emirates Court. They said it should be a federal court, not DFC Freezing Court. And you think this is a new point, and it's a clear abuse of process. That's what you're saying now.
I'm saying that them re-arguing this Sharjah in the Sharjah court after there has been a decision on that very question by Justice Roger Giles is abusive, because it is asking a different court to determine the question which has already been determined as between the parties.
I see. And you're saying they're going beyond appealing the insurance committee, and this is like a fresh point, isn't it, of law?
Correct.
Need to be determined by the Sharjah court. But I don't know, I'm still confused. If you're bringing, if let's say, if this is an insurance claim, and someone might say it's mandatory that you start your proceeding before insurance committee. I'm not claiming I understand that super clearly. Okay, I mean, a little bit, as I have heard from Ms. Sullivan, I think in the last hearing, where she said, well, the first step, you need to go to this insurance committee, you need to file a claim. I don't know how and exactly what you need to plead. And then you can go to the court without having this compulsory process starting by the insurance. And then if things goes wrong, you appeal it before a local court. And I don't know exactly how that even jurisdiction is determined. Suppose there is no jurisdiction clause. Let's say there is an insurance claim within UAE. We have seen in many contract does not make a jurisdiction clause in UAE. Let's say they will go to the natural jurisdiction somewhere, maybe Dubai, Sharjah, Schema, or somewhere else. And then you need to battle that insurance committee's finding. You bring it in a sort of appeal or whatsoever. And then I don't know to what extent you would argue that, well, then the claiming party before that insurance committee and the appealing party before Sharjah would be kept to a strict ground of appeal relating to the finding. We didn't have expert of UAE law here today, but what would stop Ms. Sullivan or the companies, Horizon or Epic, to say whatever they want to say and bringing the appeal before Sharjah against this committee?
Well, it depends upon what this, the starting point is, what has this court determined already as between the parties? It's determined that a complaint is not a proceeding. It's also determined that this court has jurisdiction. The DIFC court has jurisdiction.
And tell me, to what extent the finding of this DIFC, in your opinion, the finding of Justice Roger, to what extent is binding to a Sharjah judge or this even, the insurance committee?
Well, it's binding on the defendants. It's a final decision. Yeah. So it's a binding on the parties. And that's the whole point. That's the whole point of the anti-suit injunction that we are seeking to obtain, because we say that they are acting vexatiously and oppressively by bringing proceedings in Sharjah where they are seeking to argue the identical points which have already been determined against them.
Okay, and you saying this point behind 41, the court of the United Arab Emirates means a federal and local court is a proceeding and not appeal against a complaint within the insurance committee jurisdiction.
No, because the committee has determined that it doesn't have jurisdiction for whatever reason. So now what happens is that the Horizon and Avis have decided to bring their proceedings, to bring a claim in the Sharjah courts. Now, yes, those are proceedings. And so then it's a question of, right, what are they actually doing? What are they challenging in the Sharjah courts? Now, the insurance committee refers to the fact that, as you said, the DIFC courts have accepted jurisdiction, and they refer to the way in which they have determined that. It is not open, as I've said, to Avis and Horizon to challenge that decision of the DIFC court. And yet, notwithstanding that, they are trying to do that by this reference, what they're saying here about the fact that they're re-arguing the very same point. The same parties, we are party to these proceedings, they've been served on us, and it's Horizon and Avis. And they're saying, contrary to what Justice Roger Giles says, you, the Sharjah court, should determine that that basically Justice Roger Giles was wrong. And that's not open to it. That's not open to Horizon and Avis to argue or to contend.
Well, I see. If it's to be said to argue or to bring a proceeding before Sharjah court and arguing a settled argument before the DFC court, that'll be something else. But what if someone said this is all in loop, that this document that we're looking at now, all what's said in it is all around convincing that the Sharjah court to bring back the action into the insurance committee only?
Well, no, because if you look at this document, the way in which it's structured, and that's why I looked first of all at point A. Yeah. Point A deals with the fact that the misapplication, this is under paragraph 22, above 2022, misapplication and misinterpretation of the law and ignorance of a substantial defence submitted by the two plaintiffs regarding the absence of an arbitration clause in the insurance policy. So that is the point that they are saying.
What's the remedy sought by this document? Let's see the last. What they're praying for, I mean, here.
Well, yes, I was going to come to that in a second.
I'll see, yes.
Speaking that, if I could just, I mean, I'll take you to the relief in a moment. I was planning to do that. But the other points that I want to take you to, just if we can, as we go through the document,
yes,
is
please.
That paragraph 45.
Yes. Quite lengthy one, yes.
Just make sure that is the right.
Application of English law.
Yes.
Right. Point C.
And in bold, it says, based on the above, and since the parties to the contract have expressly agreed to submit the insurance contract, its provisions application to English law and the insurance contract, etc., the committee should not be competent to hear the insurance dispute subject to the arbitration clause. Accordingly, the dispute does not fall. Sorry, I've got the wrong reference here. Sorry, wrong reference. But then at paragraph 53, this is the another point that's being raised. It says, by referring to the text of the law number 6 concerning the establishment of the insurance authority and the amendments thereof, it becomes evident to the honourable court that the Insurance Dispute Settlement and Resolution Committee is considered a judicial tribunal and its decisions are enforceable, which confirms that the dispute before the Insurance Dispute Settlement and Resolution Committee is considered an instance of litigation. So again, that issue has already been determined by the DIFC court. The DIFC court has determined that the IDRC is not a judicial tribunal, and again, they are seeking to have that issue determined in a different way in the Sharjah court, and we say that is not open to them given the finding of Justice Roger Giles. At paragraph 55, this is the reference to the English law governing the contract. It said the issue relating to proving the foreign law is considered one of the most accurate issues, since it's about the application of a foreign law issued by a legislator of a foreign country before the national judge. It is known the task of the national judiciary is to decide on the dispute presented to it by applying the national law. And what we say about that is that it is clear from everything that the Horizon and ABIS are doing is that they are seeking to avoid the effect of English law, which is the choice of law in the insurance contracts, in an effort to apply instead federal law of the UAE. Now, at page 239 of my document, at the end, it's under paragraph 57. Yes. You will see that, as you said, and it says that on the merits, to repeal the challenge decision and refer the decision to the Insurance Dispute Settlement and Resolution Committee to decide thereon by a different tribunal. But then you see, alternatively, to repeal the challenge decision and decide again to oblige the defendant to pay the two plaintiffs an amount of $70 million or its equivalent in dirham, in addition to legal interest. So not only are they seeking that the decision of the IDRC be repealed, they are in the alternative asking the court to decide the very question which is already before this court, namely the question of whether or not there's any entitlement to an indemnity under the policy.
And he said that is a natural proceeding before Sharjah court.
Those are new proceedings before the Sharjah court, yes. In circumstances where we have already proceedings in this court in connection with that very question. And then its reply memo, which is at K295. It starts at K292. And you'll see this is paragraph 7 on page K295, reference to the defendant's position that the case is already before the DIFC courts.
Well, again, this is it's not a clear version for me, and maybe I will need the help of Ms. Sullivan to give me a clear reference.
not to hand, but it's exhibited to Mr. Wackley's statement, so we can find that. And if you bear with me one moment,
It's okay.
I will find it. It'll be somewhere in K. Hang on, this is the. Yes, I think it'll be at. Is it page 74 of? Let's see if I can find that.
K2.
I'm scrolling down. I will be there in one moment, my lord. I'm going to find it.
Okay.
It's just. Yes, here we are. It's at K392.
Yes, Mr. Craig. Yes, I have it.
So paragraph 7, as I said, the ABNIC's position in relation to the case being currently before the DIFC courts, etc., and the decision issued by this court shall have res judicata force and therefore not permitted to undermine this decision, etc. And then you see the reply of the plaintiff to this is it says the DIFC courts have not considered the merits of the case yet, whereas no merits-related arguments relating to dispute were submitted. All submitted pleas are merely formal pleas related to the jurisdiction of the DIFC courts to hear the case. First plaintiff still argues and discusses the jurisdiction of the DIFC courts to hear the case filed by the defendant. The two plaintiffs maintain the correct reading of the insurance policy gives an exclusive jurisdiction to the onshore courts to hear the case, and that the DIFC courts cannot be considered UAE courts unless this is expressly stipulated in the insurance policy. So still, the plaintiffs argue, so that ABIS and Horizon argue that despite the finding of the DIFC courts, it's open to the Sharjah courts to decide something different. At paragraph 10 of the document refers to the law and jurisdiction clause. And then it says in bold, the jurisdiction clause contained in the policy is a very common clause in the insurance policies in the UAE, always interpreted to give judicial jurisdiction to the onshore courts and never intended to grant the jurisdiction to the DIFC courts. Especially, we are fully aware of the cost of litigation before free zones, bearing in mind the defence engaged in many cases before the onshore courts, etc. So again, though, it is an argument that the Sharjah court should reconsider the decision of the DIFC court.
What's the date of this argument, of this document, Mr. Craig?
20th of August 2022. So only just over a month ago. Paragraph 15 of this document, again, it refers to the fact, this is K298 in my version, DIFC courts have not considered the merits of the case yet, as no pleas on the merits were presented during the dispute to date, and all submitted pleas are merely formal pleas regarding the jurisdiction of the DIFC courts to hear the case. Merits not adjudicated, so that the defendant can plead the conflict and contradiction of the judiciary. So in effect, it seems to be said, look, because the DIFC court has not proceeded to consider the merits, we can challenge its decision on jurisdiction. And that is obviously wrong. And then at paragraph 20, bottom of K299, you will see that there is a...
Well, if you bear with me here, Mr. Craig, I would really need to see into the Arabic version of this paragraph 15. I think it's in the previous document. If you bear with me in a minute.
Of course.
I got it, yes. Yeah, I would say that's accurate. Okay.
And then perhaps it'd be easier to look in the same document at paragraph 20.
Yes.
And above you'll see it's described as pleas on merits. And you'll see at paragraph 20 it refers to the fact that it said the plaintiffs have proven the vessel beta disappeared, the owners deprived from using and exploiting the vessel for more than 6 months, and there is no way to return the vessel. Accordingly, plaintiffs have succeeded in proving the loss suffered is covered under the insurance policy. And then at paragraph 22, you'll see it goes through the various points that have been made about the underlying claim. Its first point is the defendant claims that the damage was not occurred during the insurance period, and it says by reviewing the internal correspondences it becomes evident this statement is incorrect. Then at paragraph 23 it says that the policy does not cover the vessel in the event of storing. Then it says there's no reference to that condition within the terms of the policy. Paragraph 24 points out that the plaintiff did not pay insurance premium. But then that said, well, that doesn't matter because there's no conditions to that effect in the policy. Paragraph 25, it refers to the late notice advanced by the defendant, and it said that there was due notice. And then it said in relation to the point that there was no attempt to reduce or avoid the loss, that it appointed a security company. And then at paragraph 27 deals with the statute of limitations. And then it says at paragraph 28, accordingly, the two plaintiffs reserve their right to reply and submit any objective pleas whenever the Honourable Court sees it has jurisdiction to hear this case, etc. And then again, you'll see the repetition of the relief sought in the merits to both repeal the challenge decision, etc. Alternatively, to repeal the challenge decision and oblige the defendant to pay an amount of 70 million odd dollars. Now, of course, that again is a clear attempt to bring the issues which are before this court, by virtue of this court having accepted jurisdiction, before the Sharjah court as well. And we say that is obviously wrong. So it's not, as has been suggested, simply a question of asking the Sharjah court to revert or to consider that the insurance authority got it wrong, to reject it on grounds of jurisdiction and therefore send it back to it. No, it's far further than that. And it challenges all aspects of decisions that have already been made by this court and seeks to relitigate them. So that's the background. I'm sorry it's taken a little longer than I'd hoped to go through that, but I think that's quite important so that you actually see precisely what is going on.
I agree.
The next part of my submissions is the relevant legal principles. There is no dispute between us that this court has a jurisdiction to issue an anti-suit injunction, and I also don't understand there to be any dispute between us that an anti-suit injunction can be granted where proceedings in another jurisdiction or the pursuit of proceedings in another jurisdiction is unconscionable, meaning vexatious or oppressive, or an interference with due process of the court.
Well, you agreed on the test itself, and then now you would discuss whether this come under the test or not.
Yes.
Yeah.
So, I mean, just to clarify the test, the first decision I would like you to look at is the Société Aérospatiale case, which is at M77.
Yes.
And this was an appeal from the decision of the Court of Appeal in Brunei to the Privy Council. So although it's a decision effectively of an English court in the Privy Council, the reality is it's at the time the Privy Council was the final Court of Appeal for the courts of Brunei.
I'm well aware of that, yes.
Yes. And in this case, effectively, a Brunei resident had been killed in a helicopter crash, and his estate started proceedings in Brunei against a Malaysian company that had serviced the helicopter, and they also they commenced proceedings also against Société Aérospatiale, and they also commenced proceedings in Texas against Société Aérospatiale. And the Société Aérospatiale applied to the Brunei court to restrain the pursuit by the plaintiffs of the Texan proceedings. In other words, saying you must just bring them in Brunei. And the Privy Council held at just let me well, I just seem to have a wrong reference in my notes.
Take your time. Take your time.
Point 2 of the note is of M53. You'll see it says the Brunei, not Texas, was the natural forum for the trial of the plaintiff's action against S, and the work already undertaken by the lawyers in the Texan proceedings was not sufficient to make that court the natural forum for the termination.
You're reading next to what letter, please?
M53, and it's next to H. It's at the bottom of the page.
Oh, yes, I see. Last paragraph here.
Apologies.
Yeah.
It would be oppressive for the plaintiffs to continue the Texas proceedings because of the serious injustice to S in not being able to claim in those proceedings the indemnity or contribution from the Malaysian company for any liability S might have to the plaintiff. And if you can, I ask you first of all to look at it is page M73 of the judgment.
Yes.
And there are, Lord Gough distills 4 basic principles. The first one is opposite letter B. It says, first, the jurisdiction is to be exercised when the ends of justice require it. Do you see that?
Yes.
Second point is opposite letter C. It says, second, where the court decides to grant an injunction restraining proceedings in a foreign court, its order is directed not against the foreign court, but against the parties so proceeding or threatening to proceed. And so just to be clear there, the order that we're seeking today is not an order against the Sharjah court. The order that we're seeking is an order against the respondents, Horizon and Avis.
Clearly understood.
Third point, next to letter E, it follows an injunction will only be issued restraining a party who is amenable to the jurisdiction of the court against whom an injunction will be an effective remedy. Now, we say that in this case, obviously, that Horizon and Avis are amenable to jurisdiction because the court's already determined that it has jurisdiction over them. And then finally, at letter F, you will see it has been emphasized on many occasions that since such an order indirectly affects the foreign court, the jurisdiction is one which must be exercised with caution. So those are the 4 points to take from this page. And then at page 896 of the judgment, which is at page M77, and you will see that the phrase which starts, the court will not grant an injunction if, by doing so, it will deprive the plaintiff of advantages in the foreign forum of which it would be unjust to deprive him.
I can't follow. What is that? And next to what letter?
So between G and H at the bottom of the page, it says.
Yeah, I found it too. So the court will not grant.
Yes, so it says, just next to letter G, you'll say, since the court is concerned with the ends of justice, account must be taken not only of injustice to the defendant if the plaintiff is allowed to pursue the foreign proceedings, but also of injustice to the plaintiff if he is not allowed to do so. So the court will not grant an injunction if by doing so it will deprive the plaintiff of advantages in the foreign forum of which it would be unjust to deprive him. So what we say, taking a step back, on an application such as this, you need to be astute to what legitimate advantages are available to a plaintiff in the foreign forum, which are not available in this forum. So those are the points to take from this case. The next one is the decision in Airbus, and that is at O. Apologies, I'm just finding the particular reference. And the decision starts at O36.
Yes.
And in this case, there'd been a fatal air crash in India. And among the fatalities were two families who were British citizens living in London. And there had been proceedings in India where the crash had taken place. And the English claimants had commenced proceedings in Texas against Airbus. And part of the reason for that was because under Texan law, the claimants were entitled to an award of damages, which included punitive damages. Now, Airbus obtained an injunction restraining the Texan proceedings in India. So they applied in India and got an injunction restraining the foreign proceedings. However, that was not of any deterrent effect because the English claimants were not in India. And so what happened in this case was that Airbus started proceedings in England against the English claimants, simply seeking an injunction to restrain them from proceeding with the Texan proceedings. So therefore, there were no proceedings in England relating to the substantive dispute. The only purpose of the hearing and the applications made in England were for this injunction. And the question before the court was whether or not an English court had jurisdiction to do so, to make an injunction in such circumstances. And perhaps unsurprisingly, it found that it did not. And you'll see at 042,
Yes.
the underneath where it says the problem in the present case, he says, as I've already indicated, the first and crucial question which arises in the present case is whether the English court will grant an anti-suit injunction in circumstances where there is no relevant connection between the English jurisdiction and the proceedings in question, other than the appellants are subject to the jurisdiction and can so be effectively restrained. So it would be effectively akin to you being asked to restrain proceedings in the Sharjah courts in favour of another court of the UAE, not this court.
Right.
And then he refers to the next paragraph. I wish to first observe this question may arise not only in cases such as the present, usually described as alternative forum cases, but also in what have been called single forum cases, in which the English court is asked to grant an anti-suit injunction to restrain a party from proceeding in a foreign court, which alone has jurisdiction over the relevant dispute.
Well, Mr. Craig, I would like for the future of this hearing and litigation, you keep foreign court between two brackets, because I have seen as well in Mr. Sullivan's argument that whether Sharjah is, I think, fall under a foreign proceeding or foreign court, where this court should have granted anti-suit injunction or not. Maybe that toward the end, but just keep it in your mind.
I'm sorry, just to be clear, I mean, for our purposes, the Sharjah court is the foreign court for the purposes of the discussion, yes?
Yes.
Yeah, but my question whether does it fall under that description? Is it really a foreign court? Let's say, can English court restrain a party from bringing, a case in another court or another city of England? For example, a case in London and someone is suing in Leeds or Manchester or somewhere else. Can the English court, issue anti-suit injunction against one party not to sue? It's not about a foreign court. It's still a local matter in England. But for example, against Leeds, against Manchester, can that still be called a anti-suit injunction against a foreign court? Or there still can be granted even without using the word foreign? It's anti-suit injunction against another court, for example.
No, in that case, there would be a different procedure to stop the proceedings in Leeds. However, if you had proceedings in Edinburgh, again, part of the UK, and there were proceedings in London, then in that case, you would be able to get an anti-suit injunction.
As it's a separate legal system, isn't it?
Yes.
So Edinburgh would fall under the word foreign, isn't it?
It would, yes.
Okay, and is that because the regime is not governed by a final authority to decide? For example, in case of conflict of judgment between Scotland, England, Wales, or Northern Ireland, for example, there is no certain court would decide. There is a conflict judgment, and now here we're deciding, for example, well, the Scottish court got it, have the jurisdiction, and the others is hand lifted. As the situation in the UAE, we have the Union Supreme Court at the end of the day, and it has the power to determine jurisdiction between any court within this country, including the IFC court. So because we do have this as a final, I would say, an arching court at the end, that would determine jurisdiction at the how far it goes. For example, we end up with two conflicting judgments between DIFC and Sharjah. They won't remain conflicting forever because there is a local final authority would decide towards the end, maybe either the DIFC court jurisdiction ones, or were understanding they would need a final determination of the jurisdiction from each side before they intervene and said whether Sharjah, Abu Dhabi, or Fujairah court judgment sustain, and the other one should vanish. That's how it works usually. But so I want you to, it's course. But anyway, that's why I said I want you to keep it in mind whether are we all here fall under that a foreign restriction against foreign jurisdiction, or just to see, this can be like, this argument can be said between, let's say, Dubai and Sharjah, Dubai local court and Sharjah local court. At the end, there might be a contradicting judgment, maybe, and they would reach the Union Supreme Court, and then the judge at the Union Supreme Court said, well, we have looked at both judgments. With Dubai assert jurisdiction, Sharjah said, we have jurisdiction, but we see that jurisdiction should go to Sharjah. You know what I mean? They would do this is how it's working in UAE. And now, why you think the IFC is not or cannot be subject to this? One, I would say, judicial authority got jurisdiction, got the jurisdiction to determine jurisdictional conflict between any court within the UAE, even like DFC. It could be freezing court, it could be let's say real estate courts, it could be rent committees, and any emerged state court. So my question is, again, it's whether we fall under that categories of foreign anti-suit injunction or not.
Well, my understanding was there was no dispute because of the decision of Mr. Justice Wayne Martin in Emirates MBD and KBBO that this court can issue an anti-suit injunction to restrain proceedings in another part of the UAE. And therefore, in answer to your question, yes, for those purposes, the Sharjah court constitutes a foreign court. Now, I'm not disputing.
And would you remind me, is that Court of Appeal decision or is Court of First Instance decision?
That is Court of First Instance.
All right, okay. Well, thank you. You may go on. Yes.
Thank you. So, but just to be clear, that is the premise, and that's the basis upon which we have brought. I mean, we're dealing with this application.
Yes.
Yes. Yes.
You say something, Ms. Sullivan? I think you muted.
Sorry, I think there was also an exclusive jurisdiction clause in favour of the DIFC court. So it was a contractual anti-suit injunction in that case.
In that case, yeah.
And also vexatious and oppressive. It was pursued on both grounds, as I recall. But yes,
Okay.
I agree. My lord, the use of the word foreign is unfortunate. We use foreign because that's what the English cases say, but it's not really appropriate in the case of a federal jurisdiction like the UAE. But essentially, it is common ground between my learned friend and myself that the DIFC court may grant an injunction restraining someone from pursuing proceedings before another court of the UAE. That is the effect of the first instance decision of Mr. Justice Martin.
Okay, so we'll look at that in due course, yes.
Back on Airbus, if I may.
Yes, please.
Page 042. And just to be clear here, it's approximately halfway down the page. It's talking about in alternative forum cases, it's been stated that the jurisdiction will be exercised as the ends of justice require, in particular where the pursuit of the relevant proceedings is vexatious or oppressive. And in single forum cases, said an injunction may be granted to restrain the pursuit of proceedings which are overseas, which is unconscionable. The focus is therefore on the character of the defendant's conduct as befits an equitable remedy, such as an injunction. So therefore, just to be clear, that is what is relevant. You need to look at the defendant's conduct for the purposes of deciding whether or not it is vexatious and oppressive. And then in the final paragraph, he refers to the fact in alternative forum cases in which the choice is between the English forum and some other forum overseas, an anti-suit injunction will normally only be applied for in an English court where England is the natural forum for the resolution of the dispute. And if so, there will be no infringement of comity. Now, just pausing there, the same applies here. The DIFC court, we say, is a court chosen by the parties, one of the courts chosen by the parties. And so there is no infringement of comity to restrain other proceedings. And then at page 045.
045.
At the bottom of the page under the heading comity, he says, as a general rule, before an anti-suit injunction can properly be granted by an English court to restrain a person from pursuing proceedings in a foreign jurisdiction in cases of the kind under consideration in the present case, comity requires the English forum should have a sufficient interest in or connection with the matter in question to justify the direct interference with the foreign court, which is an anti-suit injunction entails. In an alternative forum case, this will involve consideration of the question of whether the English court is the natural forum for the resolution of the dispute, etc. And we say that in this case, the DIFC court is a natural forum for the resolution of the dispute because that is what Justice Roger Giles has said by virtue of the non-exclusive jurisdiction agreement. And then finally, in my run of cases, I come to the decision in Star Reefers, which is at page 082.
Yes. I got it, yes.
And this is a case where JFC, the defendant, had guaranteed the obligations of a charterer under two charter parties. Now, those charter parties themselves were governed by English law and subject to an arbitration agreement. The charterers failed to pay hire when due, and so the owners in March 2010, and the reason I say the date is because it becomes relevant, they started an arbitration in London. They also started one against, in conjunction against JFC, but there was no arbitration agreement, so those were effectively doomed to fail. Now, in the middle of June 2010, JFC commenced proceedings in Russia against the claimants, Star Reefers, and they asserted that the guarantees were governed by Russian law, and therefore they sought declarations that they were not binding on them. Approximately 4 months later, the claimants commenced proceedings in the commercial court seeking payment under the guarantees. And they also sought and were granted an interim anti-suit injunction, which was subsequently made into a final anti-suit injunction. And the judge found that JFC's conduct in starting the proceedings in Russia was unconscionable. Now, that decision was the decision of the first instance judge was appealed to the Court of Appeal. And if I could first of all just look at paragraph 2 on page 83. You will see that the Lord Justice Ricks
Yeah, let's read, of course.
he refers to the fact that it's analogous to a finding of the concept of abusive process. Do you see that? He says, potential question which arises in this appeal is whether TJ was right to say that the Russian proceedings were vexatious or oppressive. Suggested that on behalf of Star Reefers, the finding was an exercise in discretion and no effective appeal can be mounted against it. However, in my view, such a finding is an evaluative judgment and a condition precedent to the grant of any injunction in such a case as this, where no exclusive jurisdiction or arbitration clause has been agreed between the parties. In this respect, it's analogous to the concept of abusive process.
No, I really could not see it. I couldn't follow, actually. I'm on the page 084.
083 it should be. Sorry.
I'm sorry.
083, bottom of the page.
Okay. Oh, I see.
Yeah. So basically, he says an evaluative assessment has to be made on which there is, in theory, a right or wrong answer. And then if the answer, we're now on page 084, if the answer is that such conduct exists, then arises a question of discretion as to whether or not it should be granted. Now, paragraph 19 of the judgment refers at paragraph, it says page 085. The critical issue that remains in dispute, therefore, is as to TJ's finding that JFC's conduct with respect to its proceedings in Russia was vexatious. He reasoned as follows. First, the Russian proceedings were commenced with a view to frustrating the determination of the dispute in England. And then you'll see, secondly, you'll see the word halfway down the paragraph at the edge of the column. Secondly, the apparent weakness of the points sought to be taken in Russia suggests that the proceedings are vexatious and oppressive, notwithstanding the point is supported by evidence from a Russian lawyer. And then you will see at paragraph 23, the points taken on appeal. You will see that, first of all, the finding the Russian proceedings were vexatious, the judge was wrong to consider the purpose was to frustrate the determination of the dispute in England, and wrong to regard any apparent weakness in the argument as evidence of vexatious intent. Secondly, the judge had ignored the legitimate juridical advantage which JFC could only obtain in Russia by reference to an argument derived from Russian law. Thirdly, the judge had seriously undervalued the facts that JFC was first to commence court proceedings and had done so in its own courts and by reference to a legitimate argument, at any rate in those courts, as to the applicability of Russian law. And then he refers to the fact that he said, fourthly, a judge similarly undervalued the fact JFC had not submitted and made remarks about the need for an injunction to prevent any risk of issues in the English proceedings being resolved by an issue estoppel, etc. Now, paragraph 32 of the judgment, which is at page 89,
paragraph number, please.
089, paragraph 32.
Yes.
He says, paragraph 32, in my judgment, looking at these materials, I am unable, with respect, to agree with the judge's finding that JFC's conduct was vexatious. His first reason was the Russian proceedings were commenced with a view to frustrating the determination of the dispute in England. However, this conclusion is unjustified. There was nothing which JFC could do in commencing proceedings in Russia to frustrate any proceedings in England. At the time of JFC's issue of its claims in Russia, no valid proceedings had been commenced in England. So just pausing there, that is not the case here, because the DIFC proceedings were started in November 2021 and the Sharjah proceedings were commenced 9 months later. The second point is at paragraph 36 at 090. And you'll see the second principal matter relied on by the judge was the apparent weakness of JFC's case under Russian law. However, even on the judge's findings, this case does not fall into that special category where it can be said the foreign proceedings are based on a hopeless claim, etc. On the contrary, the judge said he was unable to resolve the issue. He was satisfied, moreover, that Russian proper law applied to the guarantees in the Russian court. He was entitled to have regard to his view about the evidence being surprising, but he was unable to reject it. This is not a case where a foreign claimant comes to the English court armed with nothing but his pleaded assertions under foreign law. In the circumstances, the judge appears to have entirely overlooked the circumstances that JFC had a juridical advantage in the Russian court unavailable to it, as it turned out, in England, namely the application of Russian rather than English law to the substance of the parties' dispute. Unless that juridical advantage can be said to be hopelessly and cynically invoked, it is a legitimate advantage. Hard to see a party can be said to be acting unconscionably when it seeks a legitimate juridical advantage in a foreign court. Now, again, that is not the case here. There is no legitimate juridical advantage of a claim in the Sharjah courts. And to the contrary, there is an illegitimate advantage and corresponding juridical disadvantage to ABNIC by virtue of the disapplication in the Sharjah courts of the choice of English law. So, to the contrary, we would say that what is going on here is an illegitimate advantage seeking to be sought by bringing proceedings in the Sharjah courts. And then paragraph 37, he refers to the fact, it seems to me it's also relevant that JFC had not submitted to the English court and made it reasonably clear it planned not to do so. Not, therefore, the typical case of vexatious conduct created by the issue of foreign proceedings in the face of English proceedings in which the foreign defendant had participated and from the consequences of which he was now seeking to extricate himself. Now, we say, first of all, that in this case, there's a difference because not only have they appealed, this is Horizon, the decision on jurisdiction, it has also sought to invoke the jurisdiction of this court by saying that these proceedings are an abusive process, and that has been maintained on the appeal. And of course, we would say the argument that it advances now, and I said this earlier, that it is no abusive process to have parallel proceedings does not stand scrutiny by reference to its own position. And if I could ask you please to look at bundle J, page 156.
J 156, yes.
56. And just so you're aware what this is Horizon's submissions in support of its application for permission to appeal to the Court of Appeal from the decision of Justice Roger Giles.
Oh yeah, the first appeal notice.
The second, no, this is the second. So this is the one that it filed.
Oh, the recent one, yes.
The recent one, yes.
And what you're referring to here in particular, this is ground 6?
At paragraph 28.2.
28, exactly, okay. In the premise, the judge was wrong to conclude that, yes.
You'll see, so the judge was wrong to conclude issuing of the claim by the respondent when those were already on foot and proceeding to determine that when that process, and on shore UAE is mandatory and a prerequisite, was not an abusive process. Rather, the judge should have concluded that the claim was an abusive process and proceeded to strike it out pursuant to RDC Rule 4.16, etc. We say it cannot have it both ways. If that is its submission on abuse, i.e., that the bringing of a second set of proceedings after one has already started is an abuse, then the pursuit of proceedings in the Sharjah court is, on its own case, obviously abusive. Now, I come to the final part of my submissions, which, having laid all the groundwork, I'm hoping I can take relatively quickly.
Yes, my lord, I would like to put a marker down at this point. My learned friend has now been speaking for 1 hour and 45 minutes, and I'm worried this is cutting into my time. I don't want to cramp him, but I need to have enough time to respond to the many points that he's raised.
I'm sure you would, yes.
So the submissions on whether or not the what's going on in Sharjah is vexatious and oppressive. And the first point is that in the Sharjah proceedings, they are seeking to relitigate questions which have already been determined by this court. And in particular, the question of whether or not this court has jurisdiction. And secondly, whether or not the IDRC is to be regarded as a judicial tribunal. And I've taken you through that as to where that's all said. And we say it is not open to the defendants to run those arguments, and that of itself is vexatious and oppressive. The second point is that there is a very real risk of inconsistent proceedings if the Sharjah proceedings are permitted to proceed. And as I said earlier, the defendants say in bringing the proceedings in Sharjah, they're just exercising a statutory right to challenge a finding that the insurance authority has no jurisdiction. And there's no risk of inconsistent decisions because the issues are different. Well, as we saw, that is wrong. It is not merely exercising an alleged statutory right. It is seeking to overturn the decision on jurisdiction. It's seeking to overturn the decision on what constitutes a judicial tribunal, and it's seeking to have the merits determined in the Sharjah courts.
Yes.
The third point is that bringing the proceedings in the Sharjah courts 9 months after these proceedings have commenced is also abusive. Now, it's accepted that we accept it's relevant who commenced first. And of course, the defendants place very heavy reliance upon the fact that they say a complaint was made before these proceedings were issued. However, those were not, the complaint and these proceedings were not parallel proceedings. It's been determined they do not constitute proceedings. These proceedings are the first in time, and the bringing of subsequent proceedings is an abuse. And we can see that, again, go back to what the defendants say. That is their very point. You can't have 2 proceedings. So there is abuse, and therefore that again is a further reason. The defendants, we say, are seeking to delay the determination of this dispute by pursuing its applications for permission to appeal. And as a consequence of that, it's prevented the progress of the claim in these proceedings. If it was legitimately going to abide by the decisions of this court, it would wait for a final determination of jurisdiction before launching proceedings in Sharjah, in which it seeks to overturn the DIFC decision and to have the dispute heard. And then finally, The defendants have advanced not a single reason as to why we should proceed in Sharjah as well as in the DIFC courts. That is relevant to the question of whether or not these proceedings are vexatious and oppressive, because if it cannot identify why it needs to proceed in Sharjah as well as in the DIFC, that indicates unconscionability. Not a single legitimate juridical advantage has been identified by the defendants. But against that, as I said earlier, there is a distinct juridical disadvantage to my clients if we proceed in Sharjah, namely that the party's choice of law may not be applied. So in summary, with all those points in mind, we say that the defendant's conduct in commencing the proceedings in Sharjah is obviously vexatious and oppressive. So that concludes my submissions on the abusive process point. The joinder, my understanding is there is no real, there's no objection for the purposes of the anti-suit injunction, and no submissions have been made resisting it otherwise. And we say, I mean, in our skeleton argument, we've set out at paragraphs, I think it's 28 to 30, the basis upon which we say that the joinder should be made. No grounds have been advanced as to why the joinder can be resisted. And so I don't think I need to say any more about that for present purposes.
Good. Thank you very much, Mr. Rick. I think that was enough for me. And Ms. Sullivan, I think we might take a short break before you have your go.
Of course. How long should we take, my lord?
I think just a minute.
Thank you very much. In 10 minutes.
Yes.
Thank you.
Yes, lovely. Good afternoon, all.
Afternoon.
Good afternoon, my lord. My lord, before I begin my submissions, I would like to take you to my client's most recent memorandum in the Sharjah proceedings, to which my learned friend didn't take you. That's at N1.
I wonder why he didn't take me.
Well, I did wonder whether he might not have read it, because it would have. He made a number of errors in his submissions, which I think a reading of this document would have corrected. Let me show you that. So it's N1. You can see this is the most recent memorandum. It was submitted on the 15th of September.
I thought you would start with just a judgment, but maybe that for the next. Okay.
Well, I'm going to come back to that, but this is the one I want to start with.
Yes. Okay. Give me the reference again.
So this is N1 is the opening page. I'm afraid this is the English version. And all I want to show you on that page is that it's submitted on the 15th of September. So this is the most up-to-date version of Horizon and Abusive submissions in Sharjah.
Right.
Now, I would like your lordship now to go to N5. Now, and it's really paragraph 8. It's quite a long paragraph, and maybe I could simply invite your lordship to read that paragraph.
Yeah, why not? We are in 5, isn't it? Okay,
It's
start with paragraph 7.
8. Paragraph 8.
Okay. I see. Each determine his own jurisdiction. Full
Exactly.
stop. Yeah.
So, there's been clarification to make clear that Horizon are not asking the Sharjah court to make any ruling on the DIFC court's jurisdiction, as indeed it shouldn't. And could I also ask you to go up to N2, my lord, and to the last big paragraph on that page. It says the plaintiffs shall rely upon the terms and conditions of the policies to their full effect and agree the policies include an English law governing law clause. The plaintiffs don't disagree that the governing law of the policy is an English law. The plaintiffs reserve their right to challenge any evidence submitted by the defendant as to its interpretation of English law, as the plaintiffs are entitled to do. So that's the position in regard to English law taken by my clients in Sharjah.
Now, sorry, what paragraph was that?
It's not numbered, I'm afraid.
I see. Yeah, this is
it's
the
the
bullet
last
points.
big one, beginning accordingly in order to apply foreign law.
Right here. Right.
So, my lord, and I would invite you, when your lordship is writing your judgment, to refer to that paragraph and read it at greater leisure. So, having shown your lordship that document, I'd like to make three initial observations. The first is that it's a very strong step for a common law court to grant an injunction where a party is contractually entitled to bring its claim in another court, because in doing so, it is indirectly interfering with the process of the other court. So it's a very strong step to grant an anti-suit injunction of this nature. My second point is the existence of parallel proceedings in more than one court is not of itself vexatious or oppressive. Something more than merely parallel proceedings has to be shown to justify the grant of an anti-suit injunction. And my third point is it's inappropriate to ask this court to interfere with the constitutional mechanism laid down by the Constitution for resolving conflicting judgments between the courts of the Emirates. That is for the Union Supreme Court.
Mm-hmm.
And I would like to show you the case of Highlander. My lord, my learned friend showed you some very old, venerable decisions of the House of Lords and Privy Council. I mean, there's much more recent.
All of it about airplane crash.
Yeah, exactly. They're very old. There's
very
much
very tragic, Mr. Craig. Yes.
Yeah, I mean, there's recent authority in the Highland case, the Deutsche Bank and Highland case.
Right.
Is one of the most important, and it was in fact cited to and referred to by Justice Martin in the Emirates NDB Bank case. But if we could just look at that, the Highland decision, can we look at paragraph? Yeah, it's if I could take you to page 061. Now,
yes, I'm on page 061.
Now, for this, there's a very important, but I'm afraid very lengthy paragraph where the Lord Justice Toulson in the English Court of Appeal is summing up the principles which apply to anti-suit injunctions. And then he says, it's helpful to start by identifying key principles, and after that I'll look at the few cases where anti-suit injunctions have been sought on the basis of a non-exclusive jurisdiction clause. This is our case. Now, I don't want to read this whole long paragraph out to you, my lord. I commend it to you for later reading, but there are a couple of points I wanted to draw to your attention. He says, one, under English law, and I say also under DIFC law, the court may restrain a defendant over whom it has personal jurisdiction from instituting or continuing proceedings in a foreign court when it is necessary in the interests of justice to do so. Now, the word foreign is slightly unfortunate in the UAE context, but I would substitute in another court of the UAE. Secondly, it's too narrow to say that such an injunction may be granted only on the grounds of vexation or oppression, but where a matter is justiciable in an English and a foreign court, the party seeking an anti-suit injunction must generally show that proceedings before the foreign court is or would be vexatious or oppressive. 3, the courts have refrained from attempting a comprehensive definition of vexation or oppression, but in order to establish that proceeding in a foreign court is or would be vexatious or oppressive on grounds of forum non-conveniens, it is generally necessary to show A, that England is clearly the more appropriate forum, the natural forum, and B, that justice requires that the claimant in the foreign court should be restrained from proceeding there. Now, my lord, I would pause just to say that there may need to be some modification of that principle in the connection with DIFC law, because as your lordship knows, there is no principle of forum conveniens as between the different courts of the Emirates. One has instead the reference to the Union Supreme Court. So I wouldn't press that in DIFC law, the claimant must show that its chosen forum is clearly the appropriate forum. But I would say that it's an obvious requirement that justice requires that the claimant in the foreign court should be restrained from proceeding there. He goes on to say, if the English court considers England to be the natural forum and can see no legitimate personal or juridical advantage in the claimant in the foreign proceedings being allowed to pursue them, it does not automatically follow that an anti-suit injunction should be granted, for that would be to overlook the important restraining influence of considerations of comity. Now, my learned friend always seemed to be suggesting, well, if we can't show that we have some legitimate advantage, it follows that he must get his injunction. But that's absolutely not the case because of the importance of judicial comity. And this I went on to quote extensively in my skeleton, where the judge says here, an anti-suit injunction always requires caution because by definition, it involves interference with the process or potential process of a foreign court. An injunction to enforce an exclusive jurisdiction clause governed by English law or DIFC law is not regarded as a breach of comity because it merely requires a party to honour his contract. In other cases, where we are, the principle of comity requires the court to recognise that in deciding questions of weight to be attached to different factors, different judges operating under different legal systems with different legal policies may legitimately arrive at different answers without occasioning a breach of customary international law or manifest injustice, and that in such circumstances it is not for an English court to arrogate to itself the decision how a foreign court should determine the matter. So what the judge is saying there is when you have an exclusive jurisdiction clause, then you're going to get an anti-suit injunction almost as a matter of right, because that's what the parties have contracted for. But where they've contracted for more than one court to have jurisdiction, it is a very big step for a court to grant an anti-suit injunction, which has the effect of restraining the proceedings in the other court.
So exclusive jurisdiction is the cornerstone here in your argument, Ms. Sullivan.
I'm sorry?
Being exclusive jurisdiction clause is the cornerstone in your argument.
Is the court not?
Is the fatal point?
Yes, no, so let me explain my position. In this application, I'm proceeding on the basis that Justice Giles was right to find that there was a non-exclusive jurisdiction clause. In other words, that my clients were entitled to bring claims in the courts of Sharjah, and that albeit the insurer is entitled to bring its claim in the courts of the DIFC. Now, as you know, we say that's wrong and we've got an appeal pending, but I have to accept what Justice Giles has found as the basis of my arguments. I'm essentially saying, well, I don't agree with what the judge has said, but if I'm wrong about that, if the appeal fails, then it still follows that the other side shouldn't be entitled to an anti-suit injunction on their own case. That's how I run my argument. So it's their case that this is non-exclusive in that it permits proceedings to be brought by either party in any of the courts of the United Arab Emirates, whether that's Sharjah, Dubai onshore, or the DIFC courts. That is their position. That is what Mr. Justice Giles has found, and that is the foundation of my arguments on this application. And I wanted, just before I leave Highlander, I wanted to say, as you can see against H on this page we're looking at, number 6, the prosecution of parallel proceedings in different jurisdictions is undesirable, but not necessarily vexatious or oppressive. And the court returned to that same point later on in the decision. If we can go down to paragraph 106, I'll tell your lordship the page number shortly. I think it's 076. Because in that earlier paragraph 50 we're looking at, the Lord Justice was simply setting out the general principles. He then comes to look at the special case of the non-exclusive jurisdiction clause, the multiple forum case. And he deals with that really at paragraph 105. And he says the starting point has to be the wording of the clause. In terms of contract law, I cannot see how a party could ordinarily be said to be in breach of contract containing a non-exclusive jurisdiction clause merely by pursuing proceedings in an alternative jurisdiction. In other words, it's not a breach of contract for my clients to bring proceedings in Sharjah. That is accepted. And then he goes on to quote with from the well-known text, the antecedent injunction. He says, where a non-exclusive jurisdiction clause does not clearly indicate whether prior or subsequent parallel proceedings in a non-selected forum are permitted or prohibited, the best interpretation will usually be that by contracting for non-exclusive jurisdiction, the parties will have anticipated and accepted the possibility of some parallel proceedings. And as a result, only foreign proceedings which are vexatious or oppressive for some reason independent of the mere presence of the non-exclusive clause will be restrained by injunction. And he says, consistently with that approach, when it comes to the question whether the interests of justice require that an antecedent injunction should be granted, I do not consider that it would be right to start with a general presumption that parallel proceedings in a non-selected forum are to be regarded as vexatious or oppressive, and that there is a burden on the party responsible for prosecuting them to make out a strong case to justify them on the ground of matters unforeseeable at the time of the contract or other exceptional circumstances. And he then goes on to, I will go through 107 because it's also very important. There are a number of reasons why I don't think it would be right to adopt such a presumption. First, it's equivalent, or at least comes to close to treating a non-exclusive clause as an exclusive jurisdiction clause once proceedings are commenced under it, whereas there is an important difference. In effect, that's what my learned friend is trying to do. He's trying to say once we've commenced in the DIFC, it's the DIFC or nothing. But that's not what the clause says. An exclusive jurisdiction clause creates a contractual right not to be sued elsewhere, though the court has a discretion whether to enforce it. In the case of a non-exclusive clause, either party is prima facie entitled to bring proceedings in a court of competent jurisdiction. Duplication of litigation through parallel proceedings is undesirable, but it is an inherent risk where the parties use a non-exclusive jurisdiction clause. Right. So, reverting to my submissions, my lord, firstly, it is important to emphasise that Justice Giles did not rule that the Sharjah court has no jurisdiction. He wasn't asked to, and he wouldn't have considered appropriate for him to make that ruling. What he ruled is that the DIFC court is one of the permitted courts under which claims under the insurance policies may be brought. And one can see that from K to 10, paragraph 25 of his judgment. He says, paragraph 25, if jurisdiction is conferred on the DIFC courts, it is shared also with the other courts of the UAE which have a civil system and which operate in Arabic. And in paragraph 26, this is essentially the basis of his reasoning. Reason has not been shown to depart from the ordinary natural meaning of the conferring of jurisdiction on the courts of the United Arab Emirates as including the DIFC courts. And therefore, my learned friend cannot and does not say that it is a breach of contract for Horizon to bring proceedings in Sharjah. And there's no question that the Horizon is disobeying in some way the order of the DIFC court. And if I could invite you to go to page G4, you will see that was the position my learned friend took when he appeared before Mr. Justice Giles. So G4.
Is it G or J?
G. I may be wrong.
Oh, we didn't have G.
Well, I
in
can't make that
this
work, so that must be the wrong reference. Never mind, I'll move on. I'll come back to that if I need to.
Please.
So my point is this. The jurisdiction clause contemplates that proceedings may be brought in more than one jurisdiction, and therefore the parties have contemplated and agreed to the risk of parallel proceedings and inconsistent judgments. That is what happened in this case. The parties have agreed on the dispute resolution clause, which, on the interpretation given to it by Justice Giles, contemplates that proceedings may be brought both in Sharjah and in the DIFC court. And of course, when I talk about proceedings, I mean court proceedings. Horizon is merely continuing with the process it began on the 7th of November 2021, when it made its complaint to the insurance authority. It was accepted by my learned friend in the earlier proceedings before Mr. Justice Giles, either party would be able to appeal an adverse decision by the insurance authority to one or other of the courts of Dubai. If you look at J36. And this is my learned friend's written submissions before Justice Giles. Little d, there is no risk of inconsistent decisions. Whatever is decided by a dispute resolution committee is open to challenge in the courts of Dubai by either party. And that's exactly what my client is seeking to do. My learned friend says, well, the insurance authority isn't a court, and therefore making a complaint to that the authority is irrelevant. That's wrong, because, as we've emphasised, as the insured, Horizon was obliged by Article 110 of the Federal Insurance Law to bring its claim against Albic by making a complaint to the insurance authority. It could not bring a claim in court until it had first made a complaint to the insurance authority. There was no other way to make a claim. The complaint has been made. It has been referred to a committee. The committee has made its decision. It has decided that it has no jurisdiction over the complaint. That decision is clearly and obviously wrong, because the basis of the committee's decision was a mistaken assumption that there was an arbitration clause. And as we know, where the parties have agreed on arbitration in an insurance policy, that is carved out of the territory of the insurance authority. But we know it's common ground. It's freely accepted by my learned friend's clients that there is no arbitration clause. And yet, even though they know that the insurance committee's decision is clearly wrong, they are seeking in Sharjah to have that decision upheld. They know very well that decision is wrong, and they are seeking to have it upheld. Horizon is seeking to exercise the statutory right given to it by Article 110 of the insurance law to challenge the committee's decision in a competent court, that is, the Sharjah court. Nothing in the judgment of Justice Giles rules that Horizon was obliged to bring its challenge in the DIFC court, merely that it could have done so. But if Horizon had brought its challenge in the DIFC court, it would have waived its challenge to the jurisdiction of that court. It is entitled to bring its challenge in the Sharjah court as a court of competent jurisdiction. It was Albic which chose to initiate a parallel claim after Horizon had begun the claims process by making its complaint to the insurance authority on the 7th of November. If, therefore, there is a risk of conflicting judgments and duplication of costs, it is Albic's decision to bring its claim in the DIFC court, which is the cause of that duplication. Of course, if Albic wished to, it could discontinue its claim in the DIFC court if it wants to avoid those risks. If it should turn out, my lord, in the future, that ultimately the Sharjah court and the DIFC court deliver conflicting judgments on the merits, there is a constitutional mechanism for determining which judgment should prevail. The Union Supreme Court is given the power to resolve conflicts between judicial authorities of different emirates under Article 99(9), as your lordship knows. This court should not interfere with that constitutional mechanism by making an anti-suit injunction, but should let both sets of proceedings take their course. So, against this background, why does Albic, the insurer, say that the Sharjah proceedings are vexatious and oppressive? Well, first of all, they say it's abusive for Horizon to pursue the Sharjah proceedings at the same time as pursuing their application for permission to appeal on the jurisdiction issue in the DIFC court. And that's wrong for a number of reasons. Firstly, as your lordship knows, Horizon was under a very tight timetable for challenging the decision of the Insurance Authorities Committee. If it had not made its challenge to the court within 30 days, the decision would have been final. And so it had no alternative but to pursue its application to the Sharjah court at the same time as its challenge to Justice Giles's first instance ruling on jurisdiction. That's my first point. My second point is it's obviously not an abusive process for a party to exercise its right to seek permission to appeal. It can't possibly be an abusive process to seek to exercise a right which is expressly conferred by the rules of court. In this case, the rules of court permit an appeal to be made, in the first instance, the judge hearing the case, and then if permission is refused, to renew its application to the full court. And that's what's happened. That is not an abuse of process. No doubt, if Albic had lost on the jurisdiction issue, they themselves would also be appealing the adverse judgment.
Well, I mean, to be fair to Mr. Craig, if he's not saying the appeal itself is abusive process, but he's saying the situation and
No,
pursuing your appeal here and then the Sharjah proceeding altogether is abuse. That's what he's saying.
Well,
In my assessment.
I'm taking his agreement. He is most clearly saying that, in effect, that the appeal is not brought in good faith, that it's brought simply for the purposes of delay. That is literally what he said in his skeleton argument, and I'm saying that is completely unwarranted. It cannot be an abusive process for a party to seek to exercise rights conferred on it by the rules of court.
Is that right, Mr. Craig? In short.
Yes, it is right. I mean, that is precisely our position as you've understood it.
Well, thank you. Yes.
Yes.
Yes, Ms. Sullivan.
It is quite wrong, my lord, to suggest that Horizon has only brought the Sharjah proceedings for the purpose of delaying the DIFC proceedings. Horizon is contractually entitled to pursue its claim in Sharjah. The pace of the Sharjah proceedings does not in any way dictate that of the DIFC proceedings. The two proceedings will proceed in parallel, and that is exactly the risk which, on Albic's case, the parties signed up to when they agreed to a non-exclusive jurisdiction clause. My lord, I also want to make the point, Horizon has never submitted to the jurisdiction of the DIFC court. This was expressly pointed out by Justice Giles in his judgment. If we look at K205, in paragraph 4, the judge said, this is Horizon's application disputing jurisdiction and seeking to have the claim form and its service set aside, alternatively seeking to have Adnix's claim struck out as an abusive process. No point is taken that Horizon is denying that the court has jurisdiction and at the same time asking that the court exercise jurisdiction by striking the claims out. No point is taken. A concession has been made. It is not right for my learned friend to come and say for the first time in this court, your lordship, without warning, that the insurer proposes to resile from its concession before Mr. Justice Giles. That is close to an abuse in my submission. That submission is not open to him. Now, the fact that the my client has never submitted to the merits jurisdiction of the DIFC court is important, because as the court has pointed out in the Star Reefers case, abuse usually arises where a party has submitted to the jurisdiction and is then trying to escape from that submission, which is what happened in the Emirates NBD Bank case. And if we could look briefly back at the Star Reefers case at page 088.
Right.
Now, I want to draw your attention to the passage which I quoted in my skeleton argument, where in paragraph 29, the case is, the judge is considering, this is again a judgment of the Court of Appeal in England, a recent judgment. They first refer to the passage in Deutsche Bank, which I took your lordship to a little while ago. And he says at the bottom of this paragraph, he says, in Deutsche Bank, the anti-suit injunction was sought on the basis of an English jurisdiction clause. I do not think Mr. Kimmins, as counsel, was able to show us a case in which a respondent, first in the field in a foreign jurisdiction, and here in its own domicile, was injuncted for his unconscionable conduct in the absence of his agreement to litigate or arbitrate in England. I do not say that it may not happen or have happened, or only that it may be a strong thing to do, and that an example of it happening has not come readily to hand. Now, we say Horizon was first in the field. Now, it's true that the proceedings before the IA have been found by Justice Giles not to be proceedings before a court. That doesn't mean it's not first in the field. It's first in the field because it's following the mandatory process, which says that you can't go to court until you first made your complaint to the IA. And that it was open to the insurer in this case to engage with the process. And instead, it was the insurer which sought to sabotage it by bringing parallel proceedings in a parallel jurisdiction. Now, Mr. Justice Giles says, well, that's not an abuse. So be it. But it doesn't detract from the fact that my client signaled its intention to follow the usual process. And it was the choice of the insurer to bring proceedings in a different forum, which has led to the parallel proceedings which have transpired. It was entirely foreseeable that this would happen. I need to turn also to the suggestion that my client is seeking to relitigate decisions made by the DIFC court in the Sharjah proceedings. Now,
do you want to say something about this Star Reefers judgment, or we jump to the?
I just wanted to point it to the point about this judge. It shows that it's an extremely strong thing where one party has started off the process, and we say we started it off by making the complaint, which is mandatory by the insurance law, and then to be told by someone who's come second to the party that the second proceedings must take priority. That's my point. And I say it doesn't make a difference that my proceedings began as a complaint to the insurance authority. The principle is the same.
Well, then, in your opinion, if the second proceeding is the fastest and the quickest in deciding things, amongst others, jurisdiction, would that make any change?
No, it's none at all. I mean, there are various arguments that could be prayed in aid. Firstly, I would suggest your lordship may know that under the insurance law, the insurance authority procedure is supposed to be very fast. It actually lays down that. I mean, we could look at the article. It's in the bundle before the court, but essentially it contemplates a very rapid decision-making process. I think the insurer has 5 working days to respond, and then there's a 15-day reconciliation process. And if that fails, then the insurance authority is supposed to render its decision within, I think, 10 or 20 working days of having all the papers. Anyway, I mean, in this case, it didn't happen. It's not quite clear.
It's more than 6 months, I guess.
Well, the complaint was initiated on the 7th of November, and the decision was handed down on the 13th of June. And that's not what's contemplated by the rules.
Yeah.
We don't know quite why. I mean, it may have been a bit of everything, the parties, the insurance authority. It's supposed to be a rapid procedure. So that was something my clients were entitled to have regard to. And they were also entitled to have regard to the fact that it's much cheaper to litigate in Sharjah. And they're dismayed to find themselves being hauled into the DIFC in a much more expensive court. I think your lordship can take judicial notice of the fact proceedings in the DIFC are much more expensive than those in the onshore courts. But I mean, essentially, that's not what this is about. I mean, my learned friend says we've identified no advantage to us in Sharjah. Well, we've identified three. One is the speedy resolution. Well, that's not really a Sharjah point, but there's a speedy resolution of the insurance authority. Secondly, is it's cheaper in Sharjah. And thirdly, is that by going in Sharjah, we don't give up, we don't waive our challenge to the jurisdiction of the DIFC. We've never accepted that the DIFC court has jurisdiction. We're still fighting that. We may ultimately lose that fight. But until we lose it, we're in. Well,
you fight it all along.
We'll still fight that, but we may lose it. But even if we lose it, it doesn't follow that we're not entitled to bring proceedings in Sharjah. Which, as I say, I mean, the course was set for Sharjah before the defendants, before the insurer issued their counteroffensive in the DIFC courts. Now, so I want to go to this point about the same issues. Now, essentially, what the DIFC court has decided is it has jurisdiction. The thrust of the Sharjah proceedings is to ask the court to reverse the insurance authority's decision that it has no jurisdiction. The insurance authority said, we have no jurisdiction because there's an arbitration clause. And they're obviously wrong about that. So my clients have understandably gone to the court and said, quash that decision, send it back to a different committee and make them consider the complaint on its merits. That is the primary relief which they're asking for. Let me show you K325. Where it's entitled Subject, setting aside the appeal decision and remanding the claim to the Settlement and Dispute Resolution Committee for issuance of a judgment by a different tribunal. So there's no conflict on that basis. I mean, Justice Giles has not made any finding about the jurisdiction of the insurance authority, and this requirement to set aside the decision and send it back to the insurance authority, that's a completely different issue. There's no overlap there. Now, my learned friend says there's overlap because there's an alternative claim that says, well, if you don't send it back to the committee, give us judgment for the amount of the insured sum. So I accept that. To the extent that there is an alternative claim, there will be overlap, because in Sharjah, my clients will be saying, pay us everything due under the policy. And then the DIFC court, his clients will be saying, we're not liable to pay for all sorts of reasons. So there is an overlap there. But that's exactly the problem you get into when you have a non-exclusive jurisdiction clause. You have parallel proceedings. Potentially, we don't know yet, we may one day end up with conflicting judgments on the merits. And at that point, it goes to the Union Supreme Court. But it will be quite wrong and premature for this court to interfere with that process by preventing my clients from pursuing their claim on the merits in a forum which the other party has agreed to by contract. In circumstances where it's quite clear that it's not abusive to have two sets of proceedings. It's, as the judges say, it's unfortunate, but it's not an abuse. I have already covered, I think, I mean, my learned friend made other points where he said there was going to be overlap. He said, oh, well, we're asking the Sharjah court to decide that the DIFC court has no jurisdiction. As you've seen from the most recent memorandum, we've made clear that is not our position. We're saying that the Sharjah court should not involve itself with the question whether the DIFC court has jurisdiction. It should simply decide the case on its merits, whether that means deciding it itself or sending it back to the insurance authority for another go. We're not asking them to say anything about the DIFC court's jurisdiction. Wisely so, because the Sharjah court has no business deciding whether the DIFC court has jurisdiction in any more than the DIFC court has business deciding whether the Sharjah court has jurisdiction. And this is a consequence of courts within a federal system. And as I've said, there is a mechanism, if ultimately there are conflicting judgments, that can be resolved as laid down by the Constitution. So I would simply conclude, my lord, by saying it has not been shown by learned friend that it is in the interests of justice for this court to grant an anti-suit injunction preventing Horizon from pursuing the Sharjah proceedings. On the contrary, justice requires that both sets of proceedings should be allowed to continue in parallel. And then just on the joinder, my learned friend has correctly identified the position. We say you should, when you, obviously not today, but you should decide the ASI application first. And that if you decide it in favour of my client, there'll be no need for you to consider the joinder application. But if you were to find against us, we would consent to joinder strictly on the basis that my clients are being joined only for the purposes of this anti-suit application. It's not to be treated as a general submission to the jurisdiction of the DIFC courts, which is still in issue. So a limited consent to joinder, so that we would be bound by any order that your lordship seeks fit to make.
And what you saying, basically you're sitting back now from defending this joinder application because you just want the court to decide it on basis of the urgent, the anti-suit injunction only.
Yes, we're saying that you
but
don't.
They want it in the merit. They want it in the merit. In the whole case, they want your D2 is to be joined forever in this proceeding. But I understand. You're not arguing whether it's contractual party or not contractual party, whether there is reason to join. But I don't think Mr. Craig is bringing this application solely on the basis of the anti-suit injunction, but for the whole proceeding, for the future of this proceeding.
Well, I'm not quite sure how that would follow, because I mean, the only reason he's seeking an anti-suit is because ABIS is a party in the Sharjah proceedings. If the Sharjah proceedings couldn't proceed, I'm not sure why he needs an injunction, why he needs to join ABIS to the DIFC proceedings.
Well, he said it's that there is turnover of an event, like he did. It turns out to them that they are the owner of the vessel. They would have a right to claim insurance coverage, and from that basis, they will need to be subject of even the declaration, the main claim forms declaration.
Right. I had not understood that to be the case.
The insurer is not liable to them. Yeah.
My understanding was that they were being joined on the basis that they couldn't approbate and reprobate the jurisdiction clause. That to the extent that it was said that the DIFC courts have jurisdiction over Horizon, it must also have jurisdiction over ABIS.
Well, I tell you what, you know what? I should stop arguing on his behalf, so I would allow him to bring
I mean, the answer is, I think the short answer, my lord, I cannot make any concession beyond that I've made. We would accept for the limited purposes, and I would ask you not otherwise to determine this. If you were to grant an ASI, then I invite you to reserve over the issue of joinder for broader purposes. And in my submission, you shouldn't get there in the first place, because this is not an appropriate case for an ASI. But I had understood this joinder to be for the purposes of the ASI application and not a general application in the proceedings.
Well, then Mr. Craig would make his point very clearly now. Mr. Craig? Before we depart, we'll come back to you, Ms. Sullivan.
You're muted.
Excuse me if I have got your position wrong, but you may correct it.
No, you're absolutely right. We have a separate application. It is not just an application in support of the ASI. It is an entirely separate application, which we made, I think, on the 29th of August. There's a separate application notice for it. Our application is clear. We filed evidence in support. We made our position clear at the last hearing. There is no evidence in opposition, and no submissions have been made in opposition to it. And for those reasons, we would say that the joinder just should go as of right.
Lord, it would
Yes.
appear there's been a misunderstanding. And so I hope you will you permit me the opportunity to make written submissions? I think that's the simplest way of dealing with this, because I'll need to take instructions. I'm afraid there's been a misunderstanding. Because I had understood it was limited to for the purpose of ensuring that ABIS was bound by any order that you might make on the ASI application.
No, I did
if it's wider than
I
that,
did
then I
not read
need
it
to-
that way.
Well, I must ask your my lordship for the indulgence of an opportunity to put in written submissions on that point. And it may be I'll take the same position. I don't know. I need to take instructions.
Oh, I see. And then in that case, I'll give Mr. Craig
I
the
need to
opportunity
see
to
if there's
respond.
an issue about it.
Do you mind if she make us any submission in regard of your application, Mr. Craig? Are you muted?
I mean,
Is it
with
too
respect-
late?
Yeah, well, I would say it is, because it's been blindingly clear since we issued that separate application what our position was. We also made that position clear in our last skeleton argument at the last hearing, that it was a separate application to join ABIS as a separate party to the proceedings, not just for the purposes of the anti-suit injunction. And then we've made the position clear again in our skeleton argument for this hearing. So that's our position on that. It's too late.
And your position now, they should not be giving extra chance to defend this. Yeah,
correct.
My lord, sorry.
Yes.
I think it might be helpful if you gave me a little time to reflect, because I think on a few minutes, a little bit of time to take instructions, it may not be an issue. So,
Not at all, not at all. I would understand that. So then, until you have an what do you call it, direction from your client, maybe we'll move on to the claimant for his final remarks about what you have said against the first application anti-suit injunction.
Thank you, Your Honour. I have 5 points, I think, to make by way of response. The first point is that we accept that parallel proceedings are of themselves not necessarily vexatious and oppressive. That is obviously what the cases say, including the passage that you were taken to in Deutsche Bank and Highland. But the point is, one has to look, therefore, at the conduct of the defendant to ascertain whether or not the conduct in bringing those other proceedings, those parallel proceedings, is vexatious and oppressive. And it's for that reason that I took you to that passage in, I think it was Airbus Industry, which said the focus is on the defendant's conduct. And notably absent from all of these submissions made on behalf of ABIS and Horizon is any attempt to explain the defendant's conduct other than the way in which we have presented it. There is, and I'll break that down. The first point is said, oh look, we had to issue proceedings in Sharjah because we had the 30 days under the insurance authority. And this is the second point, that the difficulty with that is, even if it is correct, firstly, those proceedings could have been put on hold in Sharjah by simply making an application to the judge while matters are determined in the DIFC court, if Horizon and ABIS truly intended to abide by a decision of this court. And the second point to make in relation to that is in challenging the decision or the decision of the insurance authority, ABIS and Horizon did not need to seek to challenge the jurisdiction of the DIFC court and make the submissions that we took you to. And equally, they did not need to make a claim on the merits of the policy. That was not necessary. even if you say that they had to start it.
But taking into account what Ms. Sullivan said, it's all about the merit of the insurance. He said, we would dash to the insurance committee. First of all, for that purpose, we want the insured claim amount. And that's the only way we could do it. In UAE, you need to start from that platform. I don't know where you would end up. But she said, we're not changing positions. She said, we went to the committee for claiming the insured amount. If it's not work, we will go to the Sharjah, either appealing it or asking for whatever. So we, at the end of the day, we would be claiming the insured amount, whether in the DFC court, if it's fault all around, we will come to the DFC. We will say, no, Al Buhaira is liable for the amount, for the $70 million came for. She said, that is our position would be and will remain be. We need the insured amount, or we will fight it within the DFC or where else. He said, we never change the position. We want the money. He said, we're not going to any committee for the sake of it's a committee. She said, that is the procedure's way we're taking.
No, but I disagree with you.
No, she said, not saying, she said, we're not changing our position. She said, that's the option we do have.
Yes,
and we're taking it.
So you make your complaint to the insurance committee, we issue proceedings. Now, I went to some detail to explain why it was ours constitute proceedings and the complaint to the committee does not. The first time in which proceedings are issued are in July of this year in the Sharjah courts.
Well, maybe we have wording issue, but if I can make this point, Ms. Sullivan make it so clear. Doesn't matter how you describe that insurance committee. She said, we are pursuing our rights as per the law. The law says you go to the committee, you start your insurance claim in that committee, and we don't know where we end up at the end of the day. But they said, we're going to the committee for our money. If it's not the committee, we'll go to the Sharjah court for our money. If there is conflicting judgment, we will go to the Union Supreme Court for our money. That's what she's saying. And from that, I'm saying, I mean, she said, our conduct is, she's trying to say, from what I understand, she's saying, we have one single position. We would defend it in the DFC. We would try to take our money from another venues available to us. Doesn't matter how it takes. That's what she said. What I'm saying this to urge you to say, where they're not changing their opinion or position or whatsoever. Am I right, Ms. Sullivan? From that basis.
Yeah, you are, my lord. Yes.
Yes, but our position is that it will be different if proceedings have been started in the two courts at once. Because those are so say proceedings in Sharjah had started.
No, she even said we started before you. You the trailing parties. I said, yes. She said, see, be careful of the wording. Doesn't matter if it's the insurance committee of the Sharjah court. She said, we are ahead of you. We started this proceeding. If there is someone is to be, let's say, charge of abusive process, it's the claimant in the DIFC court. It's Al Buhaira Insurance Company. That's what she's trying to say.
Yes, to which my answer is, that has already been found to be incorrect because Justice Roger Giles determined that the complaint to the IDRC was not proceedings. So however you look at it, yes, the idea is that they file a complaint at that point in time, but so what? You then end up with a situation where that complaint is decided either way, and then there is a need either to say that decision should be appealed.
Yeah, that would lead us, no, believe me, that would lead us to see what kind of a statement that was made in just a Giles statement. What kind of statement is that? How decisive is that? You know what I mean? And how binding to the parties and to the Sharjah court as well. You know what I mean?
Well, it's not binding on the Sharjah because this court has no ability to bind the Sharjah court. It is binding on the parties, though. That's the point, because of that prior decision.
But it's another point. I mean, I don't know. Ms. Sullivan hasn't brought it this, but whether the judge was asked to determine whether that is what the way that the insurance committee work in that way. What was he asked to decide? It is proceeding or not proceeding? It was in
Absolutely.
his
Yes,
jurisdiction?
can I interject? The point put was that they were it's the doctrine of lis alibi pendens, which means there's proceedings going on somewhere else. And he said no, because that doctrine only applies where you've got court proceedings and it's not a court. So to that extent, for that purpose, he's decided that the proceedings before the insurance committee can't give rise to lis alibi pendens. I'm making a completely different point, which, as your lordship has rightly grasped, that we started the process, whether you just part one is a complaint to the committee and part two is going to court if you don't like the committee's decision. It doesn't matter that part one doesn't involve a court. It still means that we kicked off the process that we had to follow first. That's my point. So the judge hasn't decided that point at all. He wasn't asked to, didn't arise.
And is that combined with the judge's statement that, and nothing says, he says nothing about you, even if in future, even if he described the committee is not a proceeding, a proper proceeding, he didn't say that you cannot go to Sharjah. He make it open, he kept it open, isn't it? The open venue for you.
He absolutely did not say we could not go to Sharjah. He said we could go to the DIFC. He made no finding about the jurisdiction of the Sharjah courts, except to say, in effect, that they had jurisdiction, because he found that basically all UAE courts have jurisdiction. So he made it clear he was not saying that we could not go to the Sharjah court.
Yeah, Mr. Greg, we're putting this, by the way, we're giving you the chance to make your case greater, bigger, better.
Yes, I mean, if I may, I mean, with respect, I mean,
Yeah.
I sat quietly while submissions were made on behalf of the respondents, and I'm not sure that I find it particularly helpful to have a constant interjection and sort of debate and further reiteration of submissions that have already been made. I'm making my reply, and I'm trying to be relatively brief to that effect.
But see, your main point is that there should be no conflicting judgment at the end of the day. Yes, that is the main point and need to be protected. Is that right?
Correct.
Correct.
So,
okay.
But
what if someone tells you in UAE you cannot have two conflicting judgments at the end of the day? It's the end of the story. Full stop. What if someone tells you within the UAE legal system, civil law or common law, civil or commercial, wherever you go, you cannot have a conflicting judgment at the end of the day? Doesn't matter what you do, doesn't matter where you go, you will end up with one judgment in the merit, and that's what the system would secure, despite the complexity of the system of many multi-emirates, even independent system or a federal system. You will end up with no conflicting judgment, and that's what the promise of the Union Supreme Court, I mean, the law said that.
Well,
then the risk you're referring to could not be there at all, Mr. Greg.
Well, with respect, there are other.
Don't forget, you made the point. You said conflicting judgment is the central point here.
No, I didn't say it was a central point.
I thought you confirmed to me that when I asked you.
No, I didn't say it was a central point. I said it was a point.
Okay, accept.
With respect. And yes, I appreciate, and the point is there may be circumstances in which you have parallel proceedings and there are conflicting judgments, and that is of itself not vexatious and oppressive. The point is, in this case, we're looking at the specifics of the defendant's conduct in a situation where it has been found, it has been determined, first of all, that the UAE court has, sorry, the DIFC court has jurisdiction. The second point is that the proceeding, alleged proceeding before the insurance committee is not a judicial proceeding. And therefore, until such time as proceedings are commenced in court, there are no on-foot judicial proceedings other than the DIFC court. So the next question is, as of once the insurance authority produces its decision, what are the options available to the defendants in that case? So either they can simply ignore that decision and participate in the DIFC court proceedings, or they can challenge that decision in the courts in Sharjah or wherever else. Now, the first point is they could choose to challenge it in the DIFC. And of course, that would make more sense because that is where the proceedings are already afoot. And just to be clear, Justice Roger Giles did not say that the proceedings in respect of an appeal from the IDRC had to be brought in Sharjah. He simply said it could be brought effectively in a number of different courts in the UAE. So that is the point. So therefore, there is a choice being made here by the defendants to not bring its complaint or its appeal from that decision, to bring it in Sharjah instead of the DIFC. So that is the first point, that it's making a conscious decision to create that multiplicity of proceedings rather
That's important. That's important argument here.
Yes. Okay. So that's the first point. It's decided to do it in Sharjah so you create the multiplicity, despite the fact this court has already accepted jurisdiction. And then the second point is connected to that. Is what did it do on its application to say, look, the IDRC got it wrong? Now, it had the alternative. It could simply have said the IDRC got it wrong that it had no jurisdiction. It plainly has jurisdiction. Please send it back to the tribunal to reconsider that question. And that question concerned whether or not English law governing means it could have jurisdiction, and secondly, the presence of an arbitration agreement. Again, they did not do that. They did not restrict themselves to that simple exercise of reverting it to the IDRC. They've gone much further. As I took you through, they first of all seek to, as I said, relitigate the issues that this court has already determined. So it's not just a question of saying...
So they're going forward is the conduct of committee,
correct.
Isn't it? Yeah.
Correct. And the point is, I mean, it said, oh, well, Sharjah is a court within the scope of the jurisdiction agreement. Agreed. But that's not the point. They do not need to say, as they have done on their application, that the DIFC court does not have jurisdiction. They do not have to say in their case before the Sharjah court that the insurance committee is a judicial tribunal. That is utterly irrelevant, other than to say we want a conflicting decision, which means we can basically say that this court plainly has jurisdiction and the DIFC court does not. And that, we say, is obviously vexatious.
Well, Mr. Craig, maybe I would agree with you, and no one can say this, like the insurance committee is a judicial body or federal judicial body or UAE court, yes, but I wonder if the defendant in the DFC said, although it's not a judicial body, but that's the only way where you start proceeding in insurance claims in UAE, and that would substitute a state court of UAE.
That was effectively argument before Justice Giles.
It's rejected, isn't it?
And it was rejected. I mean, it was because it was said it's an abusive process for us to bring these proceedings in circumstances where we've already initiated effectively the process under the insurance law. And Justice Roger Giles said no. And that is the point. And that dispenses with this suggestion that somehow the complaint was started first. That is.
Okay, tell me, Mr. Craig, if it's come to the attention of Justice Roger Giles that the proceeding started in Sharjah court, not in this insurance committee, in the point of abusive process, would he land in the same conclusion?
That I don't know, but that's a different consideration. I mean, that's a question where you'd have to look and see what was the position in relation to each of the proceedings, and you'd have to look at the conduct and ascertain whether or not what was being done was. I mean, it's all about context. It's all about why was the decision being taken to engage with these proceedings rather than not. And as I say, you ask yourself the question, why are these proceedings being pursued in Sharjah rather than there being an attempt to engage with the DIFC proceedings? Now, it said there's an advantage in Sharjah, which is not available in this jurisdiction. Well, there are 2 points to make in relation to that. First of all, the three points, which were speedy resolution, cheaper, and not wanting to waive the challenge to the jurisdiction, are first of all not juridical advantages. They are nothing to do with justice or the particular advantages available in one jurisdiction from another. In relation to those points, speedy resolution, incorrect. It's no more speedy to resolve matters in the Sharjah courts than it is in the DIFC. Cheaper, wrong, because in the Sharjah courts there is no recovery of costs, whereas in this jurisdiction you can recover your costs from the other side. And thirdly, the non-waiver to the challenge to jurisdiction. Well, you don't need to do that in order to bring these proceedings. You don't need to bring proceedings in Sharjah and advance them and bring all the claims that they have, but in order not to waive the challenge to jurisdiction.
Well, I do not. I mean, I'll put it to you, Craig, and then I'll put it exactly to Ms. Sullivan later. Well, maybe this is factors for forum non-conveniences, and that's of someone, claiming a certain jurisdiction as a matter of right. You know what I mean? You know what I mean? You said, oh, well, I'm going to the DIFC, and you think your jurisdiction clause referring to the DIFC course, then you didn't have to give the judge or anyone. It's any factors to support your intention to refer to the DIFC. It says that's your choice, isn't it? Well,
it is our choice. Yes.
Well, for forum non-convenience, where let's say, where both venues are available for parties, and then one judge will need to let go his case, maybe he would think that is a better court because maybe it's cheaper, maybe it's faster, maybe available of evidence, of witness, or whatsoever. But I don't know. It's a bit confusing because we're talking like both of you saying you're referring to your preferred jurisdiction as a matter of right. You know what I mean? And not a matter of preferential.
Yes, no, I mean, we both say we have a that we can start proceedings in a jurisdiction as of right, and I don't dispute the fact with a non-exclusive jurisdiction clause that Horizon and Abyss would have the right in certain circumstances to start proceedings in Sharjah. But we say that on the facts, this is why I go back to the point, the conduct of the defense, on the facts of this case, looking on the round, they do not have such a right because such are intended purely to stymie these proceedings.
And one more question. I'm sure this matter is really get heated up. I mean, I don't know why, but let's put this question to you. In your assessment, Mr. Craig, if I to take the direction that follow Ms. Sullivan, saying that wherever the Sharjah proceeding started with that committee, and then appealed, maybe then decided, maybe come back to the Sharjah court, and maybe the Sharjah court would need to decide the matter of insurance and the merit of the case at the end of the day. If I to decide that is fall within the jurisdiction clause, that is a Sharjah proceeding at the end of the day, whether starting the committee is just a mandatory procedures or a step by the law of insurance where party cannot end up in court without going first to the insurance. It's like compulsory mediation or compulsory whatsoever. You know what I mean? And do you think because of just a judgment, am I stopped from finding, for example, the committee is not just a committee, it is the proceeding, and that should fill in the river of the formal proceeding of one of the UAE court.
You are prevented from making that finding by virtue of what Justice Roger Giles has found. Yes. You cannot find now that the complaint constitutes.
I see that difficulty then.
Yes.
Yeah. Okay. Go on. I'm sure you have another 2 points to finish.
I do have another 2 points.
Yes,
the first is a brief point in relation to the submission to the jurisdiction. There was a reference to paragraph 4 of Justice Roger Giles' judgment in relation to no point being made about there being a submission by virtue of the abusive process arguments. That, of course, was a submission and acceptance made in July at that point in time. But we don't say that necessarily subsequent conduct doesn't amount to an admission. And of course, in that grounds of appeal that I took you to, you see that they take the point that if the judge was wrong on if the judge is right in any event on jurisdiction, they invoke the jurisdiction of this court to say that our bringing of these proceedings is an abuse because of the existence of the complaint. And again, that brings me back to the point I've made on a number of occasions.
Right.
The Horizon and ABIS cannot have it both ways. If that's an abuse, then this is obviously an abuse as well. And then my final point was to speak about the memo in the Sharjah proceedings, the 15th of September 2021 memo. And of course, that is a document which was filed after the application for an anti-suit was filed, and indeed after the interim application had been made. There was no requirement on Horizon or ABIS to submit that document. They have not sought to amend their statement of claim, and this document does not purport to do that. And we say it is simply a cynical attempt to prepare submissions which can be put before you to make it look as though they are going to comply. And there is no reason at all why they can't pull these submissions and say in due course that actually they no longer seek to rely upon them.
Right. Thank you. You can start from the last point, Ms. Sullivan, maybe.
Well, that's a fairly strong allegation of bad faith. I didn't see that one coming. That memorandum has been put in as a clarification of my client's position in the Sharjah proceedings. If they seek to withdraw it, submissions will no doubt be made. I mean, that's just an absolutely outrageous thing to say. That's just completely outrageous thing for my learned friend to say. The submission has been put in good faith to clarify the position which is taken on the record before the Sharjah proceedings, and it's just completely wrong to suggest otherwise.
He said because he says it's conflict the realities.
It's a pleading. It's a pleading that's been put in the Sharjah proceedings, and for my learned friend just to come in his reply submissions and say that's bad faith, it's not true. It's a cynical attempt. I mean, that's just quite extraordinary. That allegation should not have been made, my lord.
Well,
anyway.
It's been made, unfortunately.
Well, no, but it should not have been made. It's a completely improper allegation.
I maintain that allegation, and very strongly.
Right. Well, there's no evidence to support it. I mean, we'll have to take this up, and we're going to have to take this up in correspondence because it's completely improper to make allegations like that on the hoof. Anyway, moving on, my lord, because we don't want to get down into a.
1 second, because I really need to deal with this. I'm just trying to point the time where this allegation was made. It's at 3:35.
The allegation made, my lord, is that the submission made by my clients in the Sharjah proceedings is not a bona fide document, but in effect a cynical pretense made for the benefit of this court, which does not reflect the position they will adopt in Sharjah. And I want to know what the basis for that very, very serious allegation is.
I didn't think I would need to invest in that much, but I have made a note on it and I would deal with it myself. Sullivan.
Thank you.
You want to grapple with the next point?
So,
Well,
simply, I mean,
I'm sorry, I'm not sure. I mean, my understanding is claimant makes submissions or the applicant makes submissions, the respondent replies, makes submissions in response, and then there's a reply to the points that have been raised. That's what I've done, and that's my understanding of the way in which this procedure works. If there's going to be a constant back and forth, then so be it. But it's not in accordance with how I understood that normal proceedings proceed. But there we go.
I'll come back to you, Mr. Crick. Yeah.
That is a wholly insufficient basis for making an allegation.
Mr. Sullivan, I think we've done with this. We're done with this, Mr. Crick. You will be the last to speak. I promise you.
I mean, with respect, I haven't dealt with the allegation of bad faith because I was told that the judge was going to deal with it. I can expand why we say that, but it doesn't sound as though I'm. Well,
believe me, it's not a big point for me. Believe me, it's not a big point with me. I will not concentrate much on that. I'm sorry you felt offensive, Mr. Sullivan, about that.
Not at all. I'm not personally offended, but I mean there are ways and means of doing this, and I'm afraid that's simply not a proper way of proceeding. So simply, I mean, I think your lordship has my points. I needn't repeat myself ad nauseam. In essence, my clients are doing no more than exercise their contractual right to go to the courts of Sharjah. If my learned friend is right, an insurer could always convert a non-exclusive jurisdiction clause into an exclusive clause in favour of the DIFC courts. simply by doing, and as they've done in this case, bringing their claim in the DIFC court and said, well, you know, I don't care whether you've made your complaint to the committee. It's not a court. Now I've started my proceedings in the DIFC. It's the DIFC or nothing for you, Mr. Insured. That is essentially what he's saying, that simply because my clients had to go via the statutory procedure that involved going first via the committee, his clients are entitled to steal a march by bringing proceedings in the DIFC court and then saying it's an abuse if we try to carry on with the process we started. That is the essence of his submission. This case doesn't get near the kind of conduct that's justified findings of vexatious and abusive conduct. They're very, very rare because of the comity point, my lord.
Next week.
I mean, this is focused down on his case now. I think seems to be, well, we should have appealed the committee's decision in the DIFC and not in Sharjah. And there are essentially three reasons why we did not. One, we were contractually entitled to choose Sharjah. Why should my clients not exercise their contractual right? He has not got the ability to take that contractual right away. Two, they were under a very tight timetable of 30 days. Three, they could not go to the DIFC court without submitting to the jurisdiction. My clients have consistently taken the position that the DIFC court does not have jurisdiction over them. They couldn't maintain their appeal and at the same time ask the DIFC court to rule on the insurance committee's decision. Those are three extremely powerful and perfectly valid reasons for my clients to commence the Sharjah proceedings. Thank you, my lord.
Do you have any extra instructions yet in regard of the joinder?
Yes, we don't oppose, my lord. It's understood, and we don't oppose joinder.
Thank you very much. So, Greg, any final remark? As I promised, I'm coming back to you. You'll be the final last week. You're muted. Yes.
There was the constitutional point which you rose, which you raised in relation to there being ultimately a final decision, and that will resolve all difficulties potentially between two conflicting decisions. That is, however it may be, but the point we've got here is it's accepted that this court has the jurisdiction to grant an anti-suit injunction in respect of proceedings in other parts of the UAE. And that obviously presupposes that you want to stop the process of there being a second decision from running at all. So you don't get to the need to have a constitutional decision made of resolving those two potentially inconsistent judgments. So in my submission, that point doesn't actually arise for consideration by you in circumstances where the starting point is this court does have jurisdiction to make an ASI.
Mr. Gregg, with respect, I mean, let's discuss it this way. I mean, well, the common law inventions of certain mechanisms, such as like anti-suit injunctions, a later stage maybe were called the forum of convenience when you even give away your jurisdiction. This is all are things I think are proposed to protect the big harm that's two conflicting judgment that would happen today. At the international level, there is no union or universal Supreme Court at the end of the day, you know, between, let's say, UAE and England, Pakistan, India, Costa Rica, whatever happened, you know what I mean? But what I can see, there is a genuine, I mean, factor behind this, but we know it's an overarching reason is that we should not allow conflicting judgment. At the end of the day, I mean, a matter of people would be, people's cases would be determined at once without conflicting judgment. Without conflicting judgment would lead to maybe conflicting enforcement, or it might lead even to a political conflict between the countries. But you see, well, believe me, from my knowledge of the civil law, they didn't have such inventions at all. Like, I tell you what, if a matter between Dubai and Sharjah, none of the judges would take either positive or negative step towards any. He said, I don't care what happened in Abu Dhabi. I would deal with the cases I see. If I see jurisdiction, I would deal with it. I don't care what happened outside in the world. And I will not stand. They don't adopt anti-suit injunction because they didn't care, do whatever. They didn't care about whether there is 2 conflicting judgment or 10 conflicting judgment or even 15 conflicting judgment. But I'm telling you what my understanding. These are a common law invention. At the end of the day, it would lead to a unity of a decision at global level, even at least where common law lies. I mean, you wouldn't find a judgment in the United States, conflicting judgment in Australia or in Hong Kong or in England. And that is unity. That's good for the people, for the whole universe. And from that point, I'm said, anti-suit injunction should work in that kind of direction, that kind of mechanism. But if like you will substitute a universal Supreme Court, but you didn't need it because there is union Supreme Court, not universal, but it's a union. Okay. I said, we might not need to go that far. I tell you what, maybe the Sharjah said, well, we have no jurisdiction, stick with the DFC, then no conflicting judgment. And if there is small percentage that it would happen, then I said the union would be the last guard. Only one judgment would prevail. And what the DFC court, they might accept the appeal from Ms. Sullivan, and they might turn over the event. No problem. And then she can continue with her Sharjah procedure. We didn't know, but from that point, when I said my crucial point is whether the anti-suit injunction, it's not about the parties' conduct itself, but the parties' conduct that would lead to a conflicting judgment. Why the case? If there is any, let's go to the Russian case or to the American, the plane crash you just brought. A judgment in Texas and another judgment in Brunei. 2 conflicting judgments. How you deal with that? Anti-suit injunction. Stop. You gotta stick with one option because that's how we see it. And so forgive me for being long, but I'll try to put this before you in a small plate portion. This is the main purpose, I guess, at the end of the day. And it's maybe this will not serve a purpose by having an authority that would make sure a conflict judgment at the end of the day, doesn't matter how parties acted, how they behaved, how they misused the process, because the system got a teeth would stop all of that. And maybe. Yes.
Well, there are 2 points to make about that. The first is that the DIFC court is a common law court, and therefore invested with effectively the same powers and follow the same conclusions of the common law courts, so that's the starting point. And the second point is there is no dispute that there is first instance authority of this court, which says this court has jurisdiction to issue an anti-suit injunction both generally and in terms which would prohibit the commencement of or pursuit of proceedings in this case, it was the Dubai courts, and that's Emirates and KBBO. So, and that is obviously a circumstance, that's a case where that anti-suit injunction prevented, as it were, proceeding in I think it was the Abu Dhabi courts or the Dubai courts. So it was a case where you didn't get to the stage of having 2 inconsistent decisions because the DIFC court assumed that it had the ability to grant anti-suit injunctions restraining the proceedings in other parts of the UAE. Now, whether the other courts of the UAE have that power is irrelevant. It's simply a point that, as a matter of the law of this.
You refer to Justice Martin judgment, isn't it?
Correct. Yes, it's paragraph 77 of his decision.
Yeah.
And just to be clear, that was a decision where he considered both the exclusive jurisdiction clause and also whether or not the conduct was vexatious and oppressive.
Well, I would go to Ms. Sullivan, but she have said this point before. I mean, that maybe that judgment can be distinguished because it's, first of all, exclusive. Anyway, and another point, I'm sure I can have my own judgment in this facts too.
Oh no, I think it's right that that both the anti-suit injunction was pursued and granted on both grounds, my lord. Yes, on very different facts, I may say, but yes, it was.
Thank you. Well, thank you very much. Then I think I have heard enough from you. Thank you very much for your effort to make this. I mean, what about cost? I think maybe cost in the case at the end, or are you want to do you want a submission after the judgment maybe being delivered?
My lord, I think both parties would probably say costs to the winner of the application to be assessed, but we could do written submissions if your lordship is willing to do that, or we could convene a short hearing, whatever your lordship prefers.
I think maybe after the delivery of the judgment and then the merit.
Yeah, thank you very much.
Thank you very much for both. Have a great day ahead.
Thank you.
you.